Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Or just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous the insanus. Oy vey, Marcus. Proceed, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning, good afternoon. It's afternoon. Today is Saturday, July 26th, 2025. It is noon here on the East Coast. How's everybody doing? I was on vacation. In New Hampshire in the Lakes region. I got to see Dave Matthews while I was there in Guilford. And it was awesome. And I had an Airbnb that was like right on the lake, and it was awesome. And we had a great time. And I did the show for you, or we did a show together on, what's today, Saturday, Thursday. We covered the hearing on Brian Walshe live. And then YouTube took it down. YouTube took the show down. And thanks for you guys for telling me that it was taken down, because I wouldn't have known. Well, I did know because they sent me an email, but I was on vacation. I wasn't reading my email. So we did the show. And YouTube took it. It's the first time in hundreds of videos that I've done on YouTube that YouTube took a video down. And I don't know what the hell's going on, but here's the reason that they say that they took it down. And this was just really weird. It said, that we found that your video, where your content violated our policy on personally identifiable information. And I'm like, what? And I saw it like in the middle of the night, and I'm like, this must be because the judge named the man with whom Ana Walshe was having an affair, right? And the judge said his name like 100 times. And so I said something like, yeah, now everyone's going to go to LinkedIn and look up this guy, because I guess they used initials first. And then they said his name. But that wasn't the reason, because the timestamp that YouTube gave me was during a timestamp. Well, they just put it back up. During a timestamp where we were talking about a court filing from November of 2024, in which Brian Walshe's attorney, Larry Tipton, had asked for lots of things, demanded lots of things, including something about an NDA signed by Brian Tully with the feds. So we were talking about that a little bit. And then I talked about a lot of things at the beginning of that stream, and I couldn't figure out what it was. We also talked about, I'm going to say, Serena Vanderwoodsen and her husband and their lawsuit regarding that movie that I auditioned for. Do you remember? I have no idea if somebody reported. I have no idea. And how many YouTubers were served with subpoenas for their personal information for talking about that case, and I won't mention because maybe that was the trigger. I have no idea. It's AI. I appealed it. And then, and they said, no, you lost your appeal. They said, you can trim your video. So I trimmed the video. And the only part that I cut out was everything before the hearing. So the hearing was fine. I don't know. I don't know if it was about the Serena Vanderwood and stuff and that lawsuit and the YouTubers getting subpoenaed, and YouTube is like, anytime they hear that name, they're just going to tell people to take it down because they don't want to be served with any more subpoenas. I just don't even really know. They don't tell you if someone reports it. I don't think. I don't know. I have no idea. But let's not talk about it in the chat because even that word apparently is not friendly. I don't know. Maybe they're working overtime, but other people covered the hearing too, and their streams weren't taken down as far as I know, right, brother counsel? Hang on. Great way to make me louder is to tell me to stop talking about something. That's the best way to get me to be louder. I did mention that name. I did mention that BLVJB about how all these YouTubers were served with subpoenas. So, or Google was served with subpoenas. I have no idea. I don't know what it's about. You know me. I don't even say the F word hardly ever. Maybe once in a while. I don't allow gossip. I don't allow rumor. I don't allow trash talk about people. So I was very confused about it. But once I trimmed it, now it's fine. It's back up. If you didn't get to see it, go back and watch it. Right? So I don't know if their AI has been like stepped up a notch and now it's going after all kinds of weird things. So I don't know exactly. And people that were seeing messages saying that my video was taken down due to bullying. Like, I'm sorry, what, you were here with me, right? I had a lake backdrop. We don't bully people. That's what Twitter is for. That's why people go to Twitter. And by the way, there is someone on Twitter that you guys may watch on other people's shows who is now apparently insinuating that I am bullying her on Twitter. I am not on Twitter. I do not have a sock account on Twitter. I know it's called X now, but I'm going to call it X. And when people were chiming in about whether this person was referring to me and insinuating that I was the one behind some fake account that was bullying her, the answer is hell to the no. And why would you even be out there starting that discourse? I don't get it. I don't have time for it. And it's weird. It's just weird. Who does that? Yeah, that's just weird. If you are on there, you know who and what I'm talking about. Ridiculous. Yeah. So there's that. Yeah, it ain't me. It ain't me, kids. I don't have time for that. I have teenagers and I have a life and I don't have time to go on Twitter and spend the day there bullying people and saying that you look old or ugly or whatever the trolls are doing to this woman over there. And I don't get it. And if people are out there commenting, that sounds like Melanie. Melanie calls Twitter a cesspool all the time. Why are you talking about her and her big following? And then people are putting it out there that it's me. And then everyone's spreading it out there that it's me. It's not me. It's not me. I mean, everyone knows that Twitter is a cesspool. So that's weird. I went through the same thing and I had an old Twitter account and I got off it right away because I don't have time. Ain't nobody got time for that, especially me. I don't have time for it. I don't have time for it. So shut the rumors down that you think it's me and, get back to running for DA or whatever it is that you want to do when you move to Massachusetts, because I don't care enough. Trust me when I say that. Okay? Never met you, don't have anything against you, have no reason to go on Twitter and bully you. So when people ask you, shut it down. Yeah, John Barron. I don't even know what this is about. Some Twitter account called John Barron has been trolling and saying mean things about people. And then this person put out all this speculation and said, oh yeah, to that person who says that cesspool is a Twitter and has a worldwide following, I'm on to you or something. I don't even know. You got a million of you sent it to me. So I wanted to address it. Nothing to do with me. So there's that. No, not Etsy, SD, and it's not Coffin Doffer. It's an attorney who's out there insinuating that I'm trolling her, and I'm not. I don't have time for it. Okay? Yes. So there's that. Because so many people have asked me about it. I'm like, what are you even talking about? And then you sent it to me, and I'm looking at it, and I'm like, people are speculating that's me and saying, you got to shut it down. It's not Melanie. And then the person's like, I never said it was anyone, and just like leaves it out there. It's so weird. I don't get it. I don't have time for it. It was posted on Facebook too. Oh, thanks, Andrea. I don't do either one. I don't do either one. So there's that. Marcia says she blocks her own family. Yeah, I don't know. Whatever. I don't have time for it. Okay. So here we go. The decisions are out on the motions to suppress on Brian Walshe. Judge Freniere is the judge. We thought we liked her, but I may have to change my opinion on that. Yesterday, there was a Zoom hearing. I was traveling yesterday, and it was a really long car ride, even though I took the ferry. And by the time I got home, it was right at 2:45. I couldn't go live with it, but I did watch the hearing on Zoom. It was a hearing yesterday in front of Judge Krupp, and it was all of the attorneys, including Rosemary Scapicchio and other attorneys who represent other defendants on other cases with Proctor. And it has to do with the destruction of Proctor's text messages, because the federal order said that the messages were to be destroyed 30 days after the end of the Karen Reed trial, which would have been July 18th. But none of the defense attorneys were alerted that they were going to be destroyed until like the day before. And so they're mad. They're like, hello, some of these messages may have to do with our clients, and we don't want them to destroy these messages. And why should they destroy them? And so Rosemary Scapicchio was there for Miles King. She also represents a defendant by the name of Sean Johnson. Then there's another defendant named Brianna Gardner, who is also, I think she's a co-defendant of Miles King. There is another defendant. Her name's Bianca. Can't read my own handwriting. Ciancio. There's another defendant named Giovanni Delasanto, who's represented by Joe Krowski Jr., and also Brian Walshe. Now, remember, during the Brian Walshe hearing that we watched on Thursday, which is still up now, it's back up, Judge Freniere said, I think we have a different situation here in the Walshe case, because Ms. McLaughlin, not only are you co-counsel here, are you one of the attorneys that is prosecuting Brian Walshe, but you are also one of the prosecutors in the Karen Reed trial. So you have the benefit of having seen all of the communications of Trooper Proctor. Why the hell haven't you gone through them to see what's relevant to Brian Walshe? And you need to do that. And we have seen, after we watched Lally testify in that other hearing in Miles King, how seriously these DAs do not really take their jobs, and how they really have no policies or procedures in place for anything. And it's just like, whatevs. Like, I don't get paid enough to care. I think they make like 140 grand a year. So Freniere called out Laura McLaughlin, who had to get up and defend herself, kind of, sort of. And it's interesting. It's interesting because they're starting to be called out. So what Judge Krupp said was, here's the history of it. The original documents were turned over by the feds. The original communications of Proctor were turned over by the feds in February of 2024. And you remember that. That was in the TUI dump, February of 2024. They turned over something like 3,074 pages to Karen Reed's defense team and Lally and his prosecuting team, because Josh Levy, in a conference call with both sides, said to them, in good conscience, I cannot allow this case to go to trial, and therefore here's 3,000 pages. Do with it what you will. Good luck. The ARCA report was in there. A lot of other communications were in there between the McCabe's and the Alberts and their group messages and Proctor's text messages and lots of other things. And so I remember this hearing because Laura McLaughlin, one of the very few times that she spoke, I think it was Alan Jackson arguing. He said, listen, Judge, we just got 3,074 pages from the feds. We don't know what's in it. It could be exculpatory. We don't know. We need some more time to go through it. Laura McLaughlin got up and she said, I've been through all 3,074 pages, and 95% of it is in line with the Commonwealth's theory of the case. And there's nothing exculpatory in there. It wasn't blank pages. So we've heard her misconstrue things in open court. We've heard her tell the judge things that may or may not be true. It is the way she says it, McLaughlin. I just do a little emphasis on it. And then the judge was told that in December of 2024, that's when there was another, or the most recent federal order on these materials with regard to being destroyed 30 days after the, as such, Karen Reed trial. So apparently there's been some 30-day extension. Nothing is going to happen with those communications of Proctor's right now. And, Scapiccio was in there. She was one of the few that showed him in person. I think Krowski was there too. We couldn't, the Zoom camera didn't show the attorneys. It only showed who was on Zoom camera. And one of the attorneys that was on Zoom, his name is Cataldo, I think. And Scapiccio says, why can't we get copies of what the DA is filing with the feds? Why can't we get copies of it? That shouldn't be under a protective order. Scapiccio is my new spirit animal. She's a pistol. I love her. She's great. She's not going to put up with any of it. And they're still trying to hide the ball, you guys. The DA's office is still trying to hide the ball. And to me, that indicates that there's a lot more going on here. And it's been going on for years. Alan Lally has worked at that office for 20 years. Something else that I think Scapiccio said, or maybe, yeah, Scapiccio said, listen, Judge, the Walshe case differs because in the Walshe case, or maybe the judge said this, I don't know, McLaughlin wrote a letter to defense counsel saying that the material that they found could be exculpatory to Walshe, and that the defense counsel in Walshe should make a TUI request of their own to try and get those materials. So that's interesting, right? Oh, and then I come home from vacation and my central air conditioning like blew up. So it's I have a fan on. If it's like annoying you or if it's too loud, tell me. But I'm like Tawny Katine on the hood of the White Snake car with the fan blowing because it's so damn hot. See how long I last in here before I pass out. Hang on. So there's a couple of conferences next week. I think August 1st, they're going back on Walshe in front of Freniere at 2 p.m. And the rest of my notes are like a whole bunch of chicken scratch. August 5th, they're going to, oh, that's what they're going to do. Okay, so August 5th is going to be the continuation of the hearing on Miles King, where Lally is still on the stand. Proctor's going to have to get on the stand. I think Tully's going to have to get on the stand, and maybe some others. So Judge Krupp said, okay, let's have everyone in. Since you got to be here anyway that day, come to me at noon and we'll readdress this issue about the turning over of the Proctor communications. Right? So there's that. Oh, you were there, Dennis Sweeney? You were in the courtroom? Boy, things are getting soupy. Rosemary is unreal. August 5th, all day. Yeah, it's going to be all day. That is going to be glorious. Yeah, so if somebody, yeah, I'm waiting for them to call me back to fix the AC, so hopefully they will. Listen, I didn't grow up with AC. I grew up with a box fan in my window. Those of you who know, like a box fan, like one of those old like yellow fans. And now I can't live without it. Call me spoiled. I'm fine. It's fine. I'll be fine. So August 5th, all day. And then there's a lot of things coming up. See what else is on deck for next week. Nothing that I can see off the top of my head, but I'm sure we're going to have things to cover. So here we go. Yeah, the big box fan in the window, right? Those are the days, huh? The days of sweating. I know. Thank you for the love of the traveling trooper. That's what it said. Bullying and harassment or like revealing someone's personal information. You were there. I didn't do any of those things. So the video's back up. I edited it. But it's not a good look for people to think that I do that because I don't. Unless it had to do with Tully. I have no idea. Doesn't your opening say be cool, be kind, be classy? It does, Melissa. Sure does. She just got the silver bracelets ready and she's here. She says, it stopped Twitter a while ago. It was me that sent you the lattes. Oh, thank you, lattes. Thank you for the lattes. Lisa Marie, you need them with all this high school BS. Got my merch too. Love it. Yeah. And look, this is the third stream of mine. It's not a strike on my channel. The problem is the video gets taken down. People are looking for it. It gets shadow banned, meaning they don't push it out. There's another stream that I did on Aaron Spencer, not friendly to advertisers. They don't want me talking about that case. Same thing happened to Defense Diaries. And another stream on Brian Walshe, also not friendly to advertisers because the Google searches. So when we get to the part of the Google searches, I'm not going to talk about them. If you want to know what Brian Walsh's Google searches were, Google them. You'll be able to find them. So I don't know. The rules are crazy. There's a lot of people out there putting some really, really disgusting stuff up on YouTube. So I'm glad you like your merch, Gigi. And thanks for your super chat. So it's bizarre. Rosemary is the star of Trial 4. She knows the corruption for decades. Thanks, Nina. I haven't watched that yet. I heard that. So if you guys want to see more Rosemary Scabicchio, watch Trial 4. I think it's on Netflix. And so thank you so very much. But there's nothing worse than doing a stream that's hours and hours and hours long, just to have them tell you after you have almost 100,000 views on it, oh yeah, by the way, we're taking it down. For no good reason. YouTube is owned by Google. Yes, it is. Yes, it is. Okay. Let's get to the first decision. It's 31 pages. You're going to see the judge twist herself into a pretzel. And this is the first decision, which is the decision regarding, the search of the phones and the son's iPad. And whether or not MSP, Bukhenik, Fanning, and Guarino went outside the consent agreement between Lynn Beland and Walsh's attorney to get some fruits of the poisonous tree. Let's take a look. Get ready for the ASMR with a little bit of rant thrown in. Yes, exactly. They're exploiting kids. Families are exploiting their kids. I'm just going to delete that, Amy, but it's a great comment. Because again, they got AI bots trolling the chat. And then if you say something like that, they think that you're promoting it instead of talking about it. For example, oh my God, did anybody hear about that horrific story in Alabama with the children that were found in an underground bunker? Yeah, I want to talk about that too. And I'm going to talk about it anyway, but they're not going to like that story. You might not want to Google it if you haven't heard about it, but there was something like 10 children between the ages of 2 and 15 found in an underground bunker where there were horrible things happening to them that people would pay to do. So it's horrific. I'm going to talk about that too. Yes, exactly. It said harassment. I just covered that. Okay. I just covered it. But if you keep putting those words in the chat, it's going to happen again. So please don't do that. I don't know what it was about. It could have been about, it wasn't about, I thought it was about them outing the paramour's name in court. That's what I thought. So just be very careful what you put in the chat. It happened to be about Tully and an NDA. That was federal. So there it is. All right, here we go. Thank you, MBB. I know it's horrific. It's horrible. I have to figure out a way to cover it, the Alabama story, without saying too much, because as you know from the Aaron Spencer case, they don't like that either. They don't like that either. So everyone in the chat, just please be mindful, because I don't know, because I couldn't watch the chat back because they took the video down. I don't know if people in the chat were talking about Ana Walshe's boyfriend, naming him, where he works. Just don't do that stuff. Don't do it. Yes, it does. They do go through the chat, Jaxie. They do go through the chat. Read the terms and conditions. They do go through the chat. Trust me, I read them last night, and that is true. They have AI going through it. They do. All right. I know. Nobody knows anymore. Okay. Here we go. I do have a lot of words blocked. Here we go. Here's the decision. Let's get to it. This is the memorandum of decision and order on defendant's motion to suppress information resulting from search of electronic devices based on consent. And this is the ruling on paper number 78. This docket number, for those of you who care, is docket number 113, docket number 113 in the Brian Walshe case. The defendant, Brian Walshe, has been charged with one count of murder in the first degree, 1 count of misleading a police officer, and 1 count of unlawful conveyance of a body. Brian moves this court to suppress evidence obtained in the course of an examination of data extracted from his cell phone and an iPad 6 mini on January 7th of 2023. The defendant argues that he consented to the examination of only limited data extracted from those 2 electronic devices. Namely, his consent was limited to non-privileged communications during the time frame, and it says communications is italicized, during the time frame of December 25th, 2022 to January 6th of 2023. The Commonwealth counters that Brian consented to a full data extraction and examination of the 2 devices for the time frame of December 25th of 2022 to January 6th of 2023, limited only to the exclusion of attorney-client communications. The court held an evidentiary hearing on May 19th, May 20th, and June 18th, 2025, and received testimony from 7 witnesses. We saw most of them, and we went over that hearing together. It was all, thank you to Trial Channel for putting that all into one video that we could watch. Here's the witnesses: Cohasset PD Officer Gregory Lawrence, Cohasset PD Sergeant Harrison Schmidt, MSP Lieutenant Yuri Bukhenik, MSP Lieutenant John Fanning, MSP Trooper Connor Keefe, MSP Trooper Nicholas Guarino, and Attorney Tracy Miner. So Attorney Tracy Miner's testimony is the only one that wasn't televised. It's the only one that we haven't seen, but she did come in to testify. Interestingly, Lynn Beland did not come in to testify, and wouldn't we like to have heard from her? 27 exhibits were admitted into evidence as detailed below. And here's all the exhibits if you want to come back and read them. But some that I found interesting. First of all, for those of you new to this case, I have a playlist linked below in the comment in the video description. I don't know how many videos we're up to on Brian Walshe, but Brian Walshe's interviews were all recorded. All of them. And this was in early January 2023, 1 year after the murder of John O'Keefe. And 1 year prior to the murder of John O'Keefe, Dr. Harry Turk took the life of his wife, Katie McLean, and all of his interviews with the same players were also recorded. You may recall that none of the interviews in the Karen Read case were recorded except for Lucky Loughran. That is it. And most of the Lucky Loughran interview was about Aidan Carney. So there. So they've got transcripts. Okay, so there's the criminal docket in the district court for the District of Massachusetts. That is related to Brian Walshe's criminal charges for selling fake Andy Warhol paintings on eBay, under which he was on house arrest with an ankle monitor, but the ankle monitor did not track his whereabouts. All it did was track when he went in and out of his house. Times. Did not have a GPS tracker on it. Weird, I know. Then they have transcripts of Walshe's interviews, Brian's interviews on January 4th, 5th, and 7th. Then they have the audio files for the same interviews on January 4th, 5th, and 7th. They've got the email, the ransom, I'm going to call it the ransom email from Richard Walker to Harrison Schmidt of Cohasset PD, which was on January 7th of 2023. Then there's another interview that they have a transcript of Brian Walshe on January 8th of 2023. They've got the MSP technical assist report dated February 13th of 2023. Most importantly to me are the emails from and to ADA Beland and Attorney Tracy Miner dated January 6th. That's the consent to search his phone and iPad email. That's their agreement. Then there's an MSP interview report of Ana Walshe, that is Brian's wife. Brian's mother, and the juvenile, his 6-year-old son, on January 5th. His 6-year-old son was interviewed by Bukhenik. Apparently that one, I don't think, was recorded a report from Bukhenik. Resume of Connor Keefe, 3 gray key progress reports generated on January 7th, 2023. The resume of Guarino, an email of Guarino dated January 7th at 6:25 p.m. That's when Guarino told Tully, I found some Google searches that are really incriminating. Then there's a Celebrite extraction report of the iPad mini. Exhibit 19, a blank consent to search form. Remember when Bukhenik was on the stand? And he was asked by defense attorney extraordinaire, public defender, amazing public defender, Larry Tipton, who also represented Penny McGee, said to Bukhenik, did you have Brian Walshe sign a consent form to search his devices? He said, no. Would have been, like redundant because, we already had an email with the agreement in it. So, no big whoop. But, here's one. Here's a blank one, but it's not the one we use. We use a different one. So they admitted a blank consent to search form into evidence because he didn't think it was important to have Brian Walshe sign one. Then there's an MSP investigative report of Sergeant Bukhenik, dated January 6th of 2023. Another audio file of Brian Walshe's interview on January 8th. And there's a bio of Tracy Miner from her website, it looks like. The affidavit of Tracy Miner that she submitted with the motion to suppress. An affidavit of former ADA Lynn Beland dated June 9th of 2025. We did not see that. I have not seen that. Problem with an affidavit is that it cannot be cross-examined. She should have been on the stand. And there's an affidavit of Brian Walshe dated April 15th of 2023. There was no, the consent to search was not accompanied by the email with his correspondence, Grace. No, it was not. It was not. They admitted it as an exhibit at trial, but thanks for chiming in. As explained below, after thorough consideration of the submissions and argument of counsel and the evidence presented at hearing, the defendant's motion to suppress information resulting from the search of the electronic devices is denied. This is page 2. And for the next 29 pages, we're going to listen to Judge Freniere twist herself into a pretzel to try and make the consent. I would imagine it's going to be appealed, Madeline. I would imagine that they are going to file their notice of appeal if they haven't done so already. For the next 29 pages, Judge Freniere is going to tell us why Yuri Bukhenik, Trooper Guarino, and Trooper Fanning are more credible in her eyes than Brian Walshe's attorney, Tracy Miner. I've never, in all my decades of experience, seen a judge throw an attorney's credibility under the bus the way she's going to do in this decision. Here are the findings of fact, and these are according to the judge. This is the judge's finding of fact. Hold on. The court makes the following findings, which are based on the credible evidence produced at the hearing and the reasonable inferences the court has drawn from that evidence. The court finds that Officer Lawrence, Sergeant Schmidt, Sergeant Bukhenik, Lieutenant Fanning, and Trooper Keefe and Trooper Guarino were credible with respect to all material aspects of their fact testimony, as reflected in the findings and rulings the court makes in this memorandum. As to Attorney Miner's testimony, the court credits much of her testimony, but importantly, does not credit her recollection of the agreed to restrictions on the examination of the data extracted from the electronic devices Brian consensually turned over to law enforcement on January 26 of 2023. More specifically, the court does not credit Attorney Miner's present recollection that law enforcement examination of the extracted data was limited to communications between Brian and other persons for the period of December 25th, 2022 through January 6th of 2023. That recollection, more than 2 years after the interactions in question, is contradicted by and inconsistent with other evidence that the court finds more reliable and believable. Oops. I'm sorry, Judge, are you not aware of the goings on in the Karen Reed case? Are you not aware of the credibility issues of Bukhenik and the inverted video and the not turning stuff over and the evidence miraculously revealing itself? Are you not up on what's, I mean, I know you're sitting right now in Plymouth Superior. It's a Norfolk County case though, so I imagine you're going to have to come to Norfolk when the case, or Norfolk, as we've been calling it, Norfolk County, to try the Brian Walshe case, because that's where he's sitting in the pokey. And so, are you not paying attention? I had to look her up. So Judge Diane Freniere was appointed to Massachusetts Superior Court by Governor Charlie Baker in 2017, according to a press release by Charlie Baker, who was the governor at the time. He appointed two women at that time, Diane Freniere and Sharon Donatel. And so she's been in Superior Court since 2017. Here's a little bio about her. She currently served in 2017. She was of counsel to a firm called Markin Zussman Freniere Compton. She's a named partner, I guess. She began her legal career as an intellectual property and litigation associate at Hale and Dorr from 91 to 94. She then went on to serve in the public sector for more than 19 years as an assistant U.S. attorney for the U.S. Attorney's Office, District of Massachusetts. While at the U.S. Attorney's Office, Freniere served as a line prosecutor in the economic crime, healthcare fraud, and public corruption units. Additionally, she served in management at the U.S. Attorney's Office, supervising all of the white-collar crime units and serving as the executive assistant U.S. attorney. She graduated cum laude from Boston College Law School in 1991, received her Bachelor of Science in Manufacturing Engineering with honors from Boston University's College of Engineering in 1985. She's wicked smart. She took some time off, I guess, before she went to law school. Prior to her legal career, Freniere served as both an active duty and reserve officer in the U.S. Air Force. And she lives in Wellesley. Well, she did in 2017. I don't know. No, that was in the press. That was in the press release. All right, so let's move on. Moving on. Let's hear her reasoning for this. Officer Lawrence, and I found Officer Lawrence to be credible. He's with Cohasset PD, but every time I see CPD in a filing, I think it's Canton PD. It is Cohasset. This is Cohasset. Officer Lawrence has been a police officer with Cohasset PD for 6 years. Sergeant Schmidt has been a member of Cohasset PD for 13 years and was a detective at the time he interviewed Brian on January 4th of 2023. In early January of 2023, he was promoted to the rank of sergeant. Sergeant Smith is a member of the Metrolec SWAT team, a consortium of police departments that shares resources and personnel to form specialized teams to include a search and rescue team. He has worked on dozens of cases involving fatalities and just over a dozen missing person cases. Of those missing person cases, several involved a death as a result of medical issues. Taking of one's own life. I have to go back to talking like I don't even know what. Let me just black out that word that begins with an S. And exposure to elements. Sergeant Bukhenik has been a member of MSP for more than 13 years, has been assigned to the Norfolk County. And it says country, though. It says country, not county, because, spell check doesn't pick it up if it's a proper word. Here it is. The Norfolk Country District Attorney's Office for the past 10 years and was promoted I have to, come on, man, what? To the rank of sergeant in December of 2021. Of note, Sergeant Bukhenik memorialized a conversation he had with Attorney Miner on January 6th of 2023 regarding the extractions and examination of data from the defendant's phone and the minor's children's cell phones and tablets. Lieutenant Fanning has served with MSP for 20 years and achieved the rank of lieutenant in December of 2021. Oh, this is interesting. So Fanning became a lieutenant 1 month before the murder of John O'Keefe. Bukhenik became a sergeant 1 month before the murder of John O'Keefe. Hang on a second, I gotta switch screens. Lieutenant Fanning has served with MSP for 20 years and achieved the rank of lieutenant. He's been there for 20 years. He has been assigned to the Norfolk County District Attorney's Office for 13 years. Oh, remember, he also had businesses with Colleen Crawford about video altering or proctoring or something like such as like that. You guys found the public records, you know. He's also accused of proctoring or doctoring some video in the case of Keith Boudreaux, right? Paul Fahey was the defendant. It was a bar fight that ended in murder in Quincy, 2016. Trooper Keefe has been with MSP for nearly 8 years, and in January of 2023, he was assigned to the Norfolk County District Attorney's Office as a digital forensics examiner and cell phone analyst. Trooper Keefe attended specialized training in numerous forensic tools to include Celebrite, Burla, Magnet, Gray Key, and LexisNexis, and has certifications corresponding to those trainings. Trooper Guarino has been with MSP for 10 years. Since November of 2019, he has been assigned to the Norfolk County District Attorney's Office, where he's responsible for forensic investigations and SA investigations. Trooper Guarino, like the one involving Sandra Birchmore, in which he failed to find something like 37,000 text messages between Matthew Farwell and Sandra Birchmore. Huh. Trooper Guarino attended specialized training in numerous digital forensic tools to include Celebrite, Magnum Axiom, and Gray Key. Attorney Miner. Okay, so now she's going to turn her attention to the attorney, Brian's white-collar defense attorney, who was representing him in the fraud for the Andy Warhol paintings. Attorney Miner has been a criminal defense attorney practicing in both state and federal courts, mainly in the Northeast, for 40 years. 40 years. Attorney Miner has represented Brian for the past 8 to 10 years. Attorney Miner has experience negotiating agreements with law enforcement regarding the examination of electronic devices. But for some reason, the judge does not want to believe an attorney with 4 decades of experience. First section is called January 4th of 2023. On Wednesday, January 4th of 2023, at 11:44 a.m., Officer Lawrence was dispatched to 516 Chief Justice Cushing Highway, here and after the Walshe residence, footnote 1, which says, the Walshe residence is on Route 3A, a busy highway. It is set back from the road in the woods with a long driveway and is situated behind a used auto dealership. It's a beautiful home. You can look it up on Zillow. It's probably still there. We did that one day. More commonly known as Route 3A, after Cohasset PD received a call from Hugh Dunleavy of Tishman Speyer in Washington, D.C. Mr. Dunleavy reported that one of his employees, Ana Walshe, had not been seen since December 29th of 2022, and that her car last entered a Tishman Speyer parking lot at approximately 5 a.m. on Friday, December 30th, 2022. Mr. Dunleavy reported that the parking area where Ana's car was last logged provided easy access to Reagan National Airport. Mr. Dunleavy reported that Ana lived in Cohasset, Massachusetts, and commuted back and forth to Washington, D.C. for work. I do have merch. It's linked below in the show notes. There's a huge summary below. Just you got to close out the chat to get to it. There's a huge summary. If you're not familiar with the case, there's a playlist to all the Brian Walshe content. There is a link to the merch, a link to membership. If you can't find it, everything is there for you. When he arrived at the Walshe residence, Officer Lawrence exited his cruiser and Brian met him at the doorway, calmly reporting that his wife was missing and he wanted to file a report with the Cohasset PD. I think the judge lets us know where she's going. Brian Walshe calmly reported. She had done this before, we know. Right. Yeah, his Google searches are all going to be accurate with regard to dates and times. Exactly. And I've been screaming that since the Karen Reed trial too, about 227. I said they're going to have a problem in Brian Walshe because they want to convict Brian Walshe based on his Google searches. And now all of a sudden it's going to be accurate. Right? Brian told Officer Lawrence that he had last seen Ana on Sunday, January 1, 2023, between the hours of 6 and 7 a.m. Brian reported that Ana returned to Washington, D.C. the morning of January 1st, 2023 for a work emergency and that she had taken either Uber or Lyft to go to Logan Airport. Brian stated that he and Ana typically spoke frequently and that he had tried unsuccessfully to text his wife and then contacted her employer. Brian explained that he and Ana owned a townhouse in Washington, D.C. and gave Officer Lawrence the address of that home. He also stated that Ana drove a 2022 gray Volkswagen Taos in Washington, D.C. Brian described Ana as 5'2", 115 pounds with brown hair and brown eyes. This initial interaction between Officer Lawrence and Brian lasted for about 20 to 30 minutes. Officer Lawrence returned to Cohasset PD and filled out a missing person report using the information provided by Brian. Exhibit 3. Thereafter, Cohasset PD conducted follow-up investigation. Law enforcement contacted JetBlue Airlines and learned that there was no record of Ana flying the morning of January 1 of 2023. Further, Uber indicated that there was no record of a pickup or drop-off at the Walshe residence. Cohasset PD also contacted the Washington, D.C. Metropolitan Police and asked them to visit the Walshe's townhouse. Brian consented to the police entering the townhouse. Ana was not at the residence and there was no sign of a forced entry. At approximately 6:30 p.m. on January 4th of 2023, Officer Lawrence returned to the Walshe residence accompanied by then Detective, now Sergeant, Harrison Schmidt, to speak further to Brian. Sergeant Schmidt prearranged this interview to allow Brian sufficient time to feed his children. When the two Cohasset PD officers arrived at the home, Brian was alone with his 3 children, then aged 2, 4, and 6 years old. The family had a large German Shepherd who was inside a crate. You can't make it up. Another German Shepherd. Sergeant Schmidt and Officer Lawrence interviewed Brian at the dining room table for a little under an hour. The 3 children were freely roaming around near where the interview took place. The interview was audio recorded and a transcript of the interview was prepared. Imagine that. Audio recorded. Cohasset PD did it right. Footnote 2 says the audio recorded interview and transcripts are in evidence and both sides agree they are a fair and accurate representation of the interview. The court has listened to the recording and reviewed the transcript, which the court concluded or concludes accurately reflects the contents of the interview. The court will not detail the entire contents of the January 4th, 2023 interview now, but will refer to the contents as needed herein. At the beginning of this interview, Brian referenced Ana's flight from Washington, D.C. to Boston on December 30th, 2022. Brian then showed Sergeant Schmidt his cell phone, in particular, a screenshot from his phone. He repeatedly encouraged Sergeant Schmidt to look at his phone, stating, please look at it. Please look at anything. And if you want to look further, there's probably a year's worth of text there. If anything that If anything of that is supportive, please, I'm open. That's in the transcript. Brian explained to the officers that Ana sometimes used his phone to take photos and would send them to herself if she liked them. In addition, Brian told the officers that Ana's iMessenger came up on his phone and that he had some access to her Instagram account. iMessenger. We're talking about Facebook Messenger or iMessage. See, now I'm confused. He had some access to her Instagram account. Okay. While discussing his federal case, Brian told the officers, I don't want to hide anything from you because if that could lead to finding my wife sooner, that's the most important thing. Sergeant Schmidt reviewed Brian's phone for approximately 3 to 5 minutes, looking at photos, text messages, and JetBlue flight information. But keep all of this in mind. He has not spoken to his attorney yet. After the interview ended, Brian gave permission for Officer Lawrence and Sergeant Schmidt to walk around the Walshe residence to look for any potential clues to help them find Ana. Inside, the officers went to the basement of the home. The basement was fairly clean with a refrigerator and a couple of boxes of miscellaneous items and trash bags. Officers did not look in the attic area of the house. Outside, officers observed a Volvo XC90 SUV in the driveway. Brian gave the officers permission to inspect the inside of the vehicle, and officers observed a folded up plastic sheet in the back area of the SUV behind the vehicle seats. Officers also checked an in-ground pool in the backyard, which they found uncovered with a high water level, which I submit to you would be unusual for January, but I don't know. Do you guys not close your pools in the winter? Footnote 3 says Officer Lawrence and Detective Schmidt were unable to see into the pool and requested the assistance of a Cohasset fire department. Cohasset PD scraped the bottom of the pool to a negative result. Yeah, it's pronounced Vovo. They do pronounce it Vovo. You're right. Here they do when they were talking about it. Vovo. The sheet could be for the dog. Could be for, I don't know, poinsettias. I don't know. Could be anything. January 5th of 2023. On the morning of Thursday, January 5th of 2020. And remember, also keep in mind, they're alleging that this crime occurred in the early morning hours of New Year's Day. January 1. Cohasset PD is in the basement. He gives them permission to search the basement on January 4, 3 days later. We know there's video of him buying all these cleaning products and all these buckets and everything else. Does it smell like bleach down there to them? They don't notice anything unusual. They don't smell anything unusual. They could have, if they did, because I submit to you that if they did, perhaps they could have gotten a warrant for the house right away to have the crime scene people come back and do some, luminol and dust around and things and stuff. Hang on. January 5th of 2023. On the morning of Thursday, January 5th, 2023, Sergeant Schmidt continued his efforts to find Ana. Sergeant Schmidt created and disseminated a missing person bulletin, coordinated with Ana's friends and family members, checked for any international travel, and flagged Ana's passport to alert him if she attempted international travel, coordinated with taxi companies and ride shares and Ana's employer. In addition, Sergeant Schmidt arranged for a Cohasset PD canine search of the Walshe residence. Nothing was recovered in the canine search. Sounds like Cohasset PD knows how to do an investigation. Keep in mind also, Ana had dual citizenship with Serbia and the US. Also on January 5th of 2025, Sergeant Schmidt's supervisor requested the assistance of the MSP detectives unit. Here's where they come in to January 5th. Here comes the MSP. MSP Trooper DeChico, who has recently been rehomed, and Sergeant Bukhenik arrived at the Cohasset Command Center in the late afternoon of January 5th of 2023. And I believe the Cohasset Command Center, if I'm not mistaken, was in the parking lot of a Stop and Shop, because you just can't make this up. Michael, I'm going to delete that comment because of the word that YouTube doesn't like, but let's just say that the disassembly of Ana Walshe was believed to be in the basement with the hacksaw that he purchased, because he's on video purchasing the hacksaw. And one of the Google searches said, is a hacksaw the best tool for disassembly of a body? Okay. Sergeant Schmidt briefed Trooper DeChico and Sergeant Bukhenik on what had been done in the investigation thus far, and the three officers listened to the audio recording of Brian's interview on the prior evening. Thereafter, at approximately 8 p.m. on January 5th of 2023, Sergeant Schmidt, Detective Lieutenant Lopes, Sergeant Hunt, Trooper DeChico, and Sergeant Bukhenik went to the Walshe residence. When the officers arrived, Brian was at the home with his three children and his mother, Ana Walshe. I just want to point out also, Ana Walshe, this was a rental, this house. Ana Walshe had some sort of surgery, and she rented this house from a guy who wound up suing them for all the damages to the house and all the damages that the police did to the house. We went over that civil lawsuit on one of the prior streams. But Ana Walshe was sued, and just I don't know, keep Donna Adelson in mind when we talk about Ana Walshe. Maybe, just maybe, I have no idea really, but just, we like to think outside the box, and we've all seen Gone Girl, so there's that too. The Walshe's nanny, Robin Howe, was leaving as they arrived. The interior layout of the Walshe residence is an open concept floor plan with the dining room situated to the left of the entrance and the kitchen on the right. There's a large dining table and window bench seating. Sergeant Schmidt, Trooper DeChico, and Sergeant Hunt interviewed Brian at the dining room table. Detective Lieutenant Lopes and Sergeant Bukhenik interviewed Diana and Ana and Brian's 6-year-old son, TW, in the television living room area, which is separated from the dining area by a staircase. If you didn't see the if you didn't watch the testimony with me, go back and watch it, because the fact that Yuri Bukhenik was allowed to interview a 6-year-old should horrify you. There are people who have special skills interviewing children. He is not one of them. And Larry Tipton grilled him about it. And Bukhenik's demeanor during that testimony, by the way, he couldn't have cared less. He could not have cared less. Right? His demeanor was so different than it was during the Karen Reed trial in front of Judge Cannone. So different. He was cocky in front of Judge Cannone. He was not cocky in front of Judge Freniere. He was a little nervous. And maybe, jig is up, the news is out. They finally are figuring it out over there in the county. Brian's January 5th, 2023 interview was audio recorded, and a transcript of the interview was prepared. Footnote 4. That is super small font. Hold on. Which says, the audio recorded interview and transcript are in evidence, and both sides agree they are a fair and accurate representation of the interview. The court has listened to the recording and reviewed the transcript, which the court concludes accurately reflects the content of the interview. The court will not detail the entire contents of January 25th, 2023 interview, but will refer to the contents as needed herein. During the interview, the children are heard in the background. In addition, a female voice and male voices also can be heard in the background, presumably Diana and the law enforcement officers interviewing her. None of the background noise is transcribed. They're also not saying that Ana Walshe's interview or the child's interview was recorded. Find that interesting too. The interview lasted just under an hour. Throughout the interview, Brian is calm and cooperative and consistent with his interview on January 4th of 2023, reportedly indicated that he wanted to cooperate with law enforcement's investigation to find his missing wife. Brian told Sergeant Schmidt and Trooper DeChico that he typically had daily contact with his wife, had no concerns about Ana committing the act of taking her life, and that neither spouse was involved in an extramarital affair. Brian explained that the sources of Ana's stress included work, her physical distance from Brian and their children, and Brian's criminal matter in federal court. Brian reported that he did not argue with Ana the morning of January 1 of 2023. Well into the evening interview, Trooper DeChico asked Brian if the police could download his phone. Specifically, I'm going to read the transcript to you between DeChico and Brian. And remember, keep in mind also, this is before Brian spoke to his attorney and before there was anything in writing about a consent search. This is kind of a frightening decision to me. It's a little bit chilling. And so hang on. DeChico. Okay, well, I know you said you're willing to, do whatever you can to help the investigation. We thank you for that. And, part of that, I think, is trying to understand Ana. I think if you would allow us to look through your phone and consent to us downloading your phone and seeing some of the communications between you and her, I'm going to highlight that, like her tone. I believe you said in the interview, she said that she may have used your phone occasionally to send and receive stuff. Brian says, yeah. DeChico, I think it'll help us really create a permanent timeline of the events. Does that sound familiar to you? Of the 1st and the 31st and the 1st, and maybe get a better insight into Ana. Is that something you'd be okay with? Note the highlighted portions, communications between you and her, and like her tone, timeline between the 31st and the 1st. Is that something you'd be okay with? Mr. Walsh, so just to be clear, you want to download everything on my phone? DeChico, we will download, with the extraction, we'll download all the contents to your phone. Yes. Walsh says, oh, that's a lot. Then Schmidt chimes in. What we're focusing on, though, is, well, what we're interested in, yes, it downloads everything, but what we're interested in is in locating Ana and finding the information specifically in there that would help us do that. The Ana specific content. That is Schmidt. He's Cohasset PD. Brian says, that's a huge amount of personal information, gentlemen. Schmidt said, it's a big ask, but there's a lot on the line. Brian says, no, there is a lot on the line. Schmidt says, you know what I mean? Walsh says, uh-huh. DeChico says, what's your concern? Brian says, I don't know. DeChico says, is it your other legal issues? Brian says, that's one of them. I guess my request would be, I'm willing to do anything, but my only request would be because Tracy Miner called me today about what's going on. Schmidt says, who's that? Walsh says, Tracy Miner is who's representing me in my other legal issues. Schmidt says, okay, yep. Walsh says, so she said, before you do anything like this, you have to talk to me. I want to do everything I can to support this 100%, but I gotta call her about it. Schmidt says, she said, before you do anything like turn over the phone or anything. Walsh said, no, before you do anything. I mean, because she always wants to be here to talk to law enforcement. I said, well, I'm going to talk to them and give them whatever they want, but I have to ask her quickly about that. I'm sure it'll be fine. Or she might say, can we just do the information that you're asking for? Schmidt says, right. DeChico says, well, that's all we would be interested in. We'd be interested in your communication with Ana. And the dates of, the 31st and the 1st through the present. We're not interested in your other past and your other issues. This is DeChico. Walshe says, I understand. DeChico says, and that being said, I believe, we would, you're represented by counsel in that matter. I don't, I'm not a legal, despite being a police officer, I'm not a legal expert, but talk to your attorney. But I believe that would require a search warrant for that stuff to be used against you, and that's not what we're looking to even go into. Walshe says, how long would it take for you to download it? DeChico says, it would take, once we hook it up to the machine, which is in Canton, it would take, depending on how many gigabytes of data it is, it's a lot. Is it a lot? Or Walshe says, yeah, like 128 or something. Schmidt says, it's a smaller one. DeChico, then I don't know, it could be 30 minutes, 30 to an hour. Walshe says, okay, so an hour of time to Canton. DeChico says, yeah, call it an hour to download. Yeah, I mean, I think it would be useful to our investigation, and I think it would be, and Walshe says, okay. DeChico says, helpful if you would consent to it. Walshe says, all right, well, I want you to know that that is my intention. DeChico says, sure. Walshe says, and my only request is to talk to Tracy and let her know that that's what I want to do. At least let her give me what my risk exposure would be in life right now. Schmidt says, just so you're aware, if it's any peace of mind, like, we don't have a crime. We're not investigating a crime. This is a missing person. Walshe says, no, Schmidt says, Walshe says, I understand. Schmidt says, we're here out of a community caretaking function. Schmidt says, just so we're abundantly clear, it's like, Walshe says, DeChico says, okay. Mr. Walshe says, no, I'm fully aware of that and I appreciate it. And I want you to know I'm not going to. I'll be very quick with it. And if Tracy and I can talk in the morning, then what would be the process? I would just give you the phone, or I would come to Canton, or I need to be away. I do a lot of work on the phone as well. DeChico says, well, we could come and get it, and we could actually potentially do it here. Schmidt says, yeah. Walshe says, oh, really? Okay. DeChico says, we have a portable device. We could. Walshe says, okay. DeChico says, just bring it here and do a download. There's a guy who works in my office that does it really efficiently, and I could send him over. Walshe says, okay, great. So will you gentlemen, honor my request to give me a minute to talk to Tracy about it? DeChico says, well, no one's taking your phone from you. And then there's some indiscernible simultaneous speech. Walshe says, no. But I'm only interested in finding Ana. And DeChico says, yeah. Walshe says, don't care what it takes, but I just have to make sure that, that I listen to all the advice that I have coming my way, which is a lot. I do apologize, but I most likely will be able to do that, and I'll be able to do it tomorrow. And that is my intention and my declaration. And DeChico says, okay. And then the decision goes on to say, Brian emailed Attorney Miner the evening of January 5th of 2023 to tell her that the police had requested his consent to search certain electronic devices. As the January 5th, 2023 interview continued, Trooper DeChico asked Brian to bring his children to a forensic interview the following morning at 10 a.m. Although Brian initially agreed to the forensic interviews of the children, he canceled the interviews the following morning. After the January 5th, 2023 interview ended, Brian gave the officers permission to search his entire home, and the officers did so. This search included the attic, which had not been searched the prior day. Listen to this. And we heard this on the stand and we were like, what? Based on their experience, the officers knew that that blank victims, the ones who take their own lives, have been located in crawl spaces and attic areas. Anybody else know that when people take their own life, they often do it in a crawl space or an attic? I would say that's more where people would hide the people that they've done away with. That's bizarre to me. It's in the judge's decision. And we did hear Bukhenik say that on the stand. I believe it was Bukhenik, right? Officers noted a hole in the drywall ceiling between the attic access and the Walshe's bedroom. Outside, officers again flashed lights into the pool and looked inside the Volvo X90 SUV. Brian provided keys to the Volvo X90, and inside the vehicle, officers found a receipt from Lowe's and a cell phone. Brian stated that the cell phone inside of the Volvo X90 belonged to his oldest son, TW. He is 6. She didn't say that, but I'm telling you that. Sergeant Schmidt observed vacuum marks on the interior carpeting of the vehicle and noted that the plastic sheeting that had been in the back area of the vehicle on January 4th of 2023 was no longer there. Okay, the judge doesn't say this in her decision, but I think it was Bukhenik. It was one of the officers who was cross-examined by Tipton and said, okay, so you noticed that the plastic sheeting was no longer there. Did you ask Brian where it was? And the officer said, yeah, I did. And he said, well, what did Brian tell you? And he said, Brian pointed at the garbage can. And then he said to the detective, did you go into the garbage can to look for it? And he was just like, no. Not in the decision, but we remember because we watched the hearing, the evidentiary hearing. Among other items, the officers were looking for Ana's cell phone, but did not find it. Officers checked the outside trash bins, but did not find the plastic sheeting or retrieve anything else. That's not the testimony. Testimony was he pointed at a garbage can inside the house, and they did not check that one. So thanks, Judge, for tossing that in there. But correct me if I'm wrong, you guys, because we listened to the hearing. We were there. At the same time that Brian was being interviewed the evening of January 5th of 2023, Sergeant Bukhenik and Lieutenant Lopes interviewed Ana Walshe and 6-year-old TW at the Walshe residence. This interview was not audio recorded, but due to the open concept floor plan, parts of it can be overheard on Brian's audio recorded interview that was taking place in the dining room. Well, thanks, Judge. Did you pick up bits and pieces, bits and bites of that interview when you were listening? Did you? During her 15-minute interview, Diana stated that she had hired a top private investigator in Washington, D.C. to locate Ana, and she shared the contact information of that individual with the police. Diana confirmed that Brian arrived at her Swampscott home on January 1 of 2023 without his phone, and that he asked to use her phone to contact Ana. After her interview, Diana was present for TW's interview. This is where it gets interesting. Hold on. Well, I got to adjust this fan so it's blowing on me. Better move it closer. I'm going off camera for 1 second. Be right back. BRB. Here's where it gets interesting. Ready? After her interview, Diana was present for TW's interview, and he sat on her lap throughout. He's 6. TW stated that he heard a noise in the early morning of January 1, 2023, and when he came downstairs, he saw Ana on the couch underneath his blanket, which he left there overnight. Ana was wearing pink pajamas with red hearts. TW saw his iPad on the kitchen island and picked it up. TW realized the iPad wasn't working and handed it to Ana to fix it, and she did. Ana then went upstairs and came downstairs wearing her real clothes, in quotes, carrying a brown duffel bag and a purse. I think I remember the testimony was that it was a 2-foot-long duffel bag. TW believed Ana's taxi was at the house. Taxi, he says taxi. He doesn't say Uber, doesn't say Lyft, he says taxi. He told his mother that he loved her, and she responded, I love you more, and she left. Sergeant Bukhenik began to ask TW if he knew where his mother was, but before he could finish his question, Diana interrupted and began flailing her arms and interjected the words, quote, your mother's cell phone to replace your mother. Like, do you know where your mother's cell phone is? TW did not respond to Sergeant Bukhenik's intended question or Diana's replacement question. He stated that his mother wanted to bring him down to Washington, D.C. He abruptly got up and ran to another part of the home. Interesting, right? Bukhenik said he ran to the basement door. She didn't put that she didn't put that in her order. Sergeant Schmidt and Trooper DeChico returned to the Cohasset Police Department at approximately 10:30 p.m. and continued efforts to find Ana, checking for recent bank activity. Also on January 5th of 2023, Trooper Keefe examined exigent cell phone records received from Verizon and determined that the last time Ana's phone had contacted a cell tower was at 3:14 a.m. on January 2nd of 2023, and that the device connected to a cell tower on Reservoir Road in Cohasset, approximately a quarter mile from the Walshe residence. Next section, January 6th of 2023. On Friday, January 6th, 2023, MSP brought in additional assets to conduct a large-scale search for Ana. Chief Quigley held a press conference characterizing the case as a missing person investigation. MSP Chief Quigley. Also on Friday, January 6th, Brian went to Attorney Miner's home to discuss Trooper DeChico's request to download and examine Brian's phone and other digital devices. Footnote 5. Which says, Attorney Miner reached out to Brian on the afternoon of January 5th, 2023, after learning that Ana was missing. Late on January 5th of 2023, Attorney Miner received an email from Brian stating that law enforcement wanted to download it and examine Brian's phone and other digital devices. Brian brought his cell phone and TW's iPad to Attorney Miner's home. Attorney Miner had concerns about turning over any devices to law enforcement for examination because, as she testified at the hearing, quote, I don't like to give the government anything, end quote. Attorney Miner explained to Brian what the Commonwealth wanted and explained his rights. Footnote 6, which says, Attorney Miner observed Brian listening to her and believes he understood what she said. Attorney Miner knew that law enforcement would perform a full data extraction, quote, a mirror image of the devices Brian turned over. Attorney Miner testified that there was no ambiguity as to what law enforcement was looking for. However, Attorney Miner's present recollection and understanding of the agreement she discussed and negotiated with law enforcement was that Brian would turn over his phone and his son's iPad, and that the Commonwealth would only look at communications between Brian and another person for the period of December 25th, 2022 through January 6th, 2023, excluding attorney-client communications. Attorney Miner reviewed Brian's phone and TW's iPad for several hours. This is important to me. His attorney reviewed them for several hours. Why didn't she didn't see the Google searches? Because if she did, you can bet your ass she wouldn't have turned them over, right? She specializes in white-collar crime. She probably has a lot of experience with electronic devices in fraud cases and other types of cases. Maybe not the M1 cases, but other types of cases. And the judge says, during her review of Brian's phone, Attorney Miner identified a marital communication prior to December 25th, 2022 that she had some concerns over. She found no text messages, emails, phone calls, or voicemails during her review of TW's iPad. Okay. But what the judge also does not say in this order is that what they specifically were looking for, the type of communications they were looking for in the iPad, was any communications that Ana might have had with JetBlue and JetBlue's chat feature, because oftentimes when she changed her flights, instead of calling JetBlue, she would chat with them over the app on the iPad. That is a communication. I'm not mentioning it here. So there's that. And if she looked at it for several hours, we don't know this because we didn't get to see her testimony. They didn't show her testimony for whatever reason. It was not recorded. We did not see it. I don't know which day she testified. In the 3 p.m. afternoon hour of January 6th of 2023, Sergeant Bukhenik had several, likely 3, conversations with Attorney Miner regarding Brian's consent to the digital evidence extraction of certain electronic devices. At that time, Sergeant Bukhenik knew about 2 phones: Brian's phone that had been missing on January 1 of 2023, but located on January 2 of 2023, and TW's phone, that was the child's phone, found in the Volvo XC90. Sergeant Bukhenik first told Attorney Miner that law enforcement wanted to do a full system extraction of the phones, more commonly known as a phone dump. Attorney Miner stated that she needed to talk to her client, and within a short time, she called him back and stated they would consent to the requested extraction with some limitation, footnote 7. Based on her concern regarding the pre-Christmas marital communication, Attorney Miner suggested, and Sergeant Bukhenik agreed to, a date limitation of December 25th, 2022 to January 6th of 2023. She also asked that the search exclude her attorney-client communications with Brian. Attorney Miner wanted to document their verbal agreement. In addition to the 2 cell phones, Sergeant Bukhenik asked for TW's iPad 6 mini, based on his interview of TW the prior evening. Sergeant Bukhenik knew that if Ana manipulated TW's iPad before she left the Walshe residence, there would be a digital imprint of the same found in the iPad's extraction. He did not explain why he wanted TW's iPad to Attorney Miner. Once the agreement was struck, Attorney Miner explained it to Brian. Okay, that's wrong, because they talked about JetBlue, right? And the chat feature on JetBlue. Am I making this up? Am I making it up? Sergeant Bukhenik contemporaneously memorialized the agreement he reached with Attorney Miner in an investigative report, Exhibit 22, footnote 8. We know how long it takes some of these players to draft their reports, and we know how they backdate them. We just saw somebody testify. I'm conflating all of my cases now, but was it Fanning who testified that just last week he wrote some chain of custody reports? I think it was in the Miles King case. Oh yeah, and he backdated it to, 4 years ago or something. Was Fanning, right? Was it in this case or was it in the Miles King case? He backdated them, to like 4 years ago. Because, sometimes it's hard to write reports and things and stuff. Thank you. It was this case. Thank you, big old dog. It was this case. Oh, it was in this case. Thank you. Yes. Okay, good. Good. Fanning testified in this case that he just made some reports last week, but he dated them all the way back to the date of, January of 2023. Yep. Thank you. Thank you for helping me, because my brain has so much stuff in it. Sometimes it gets confused. It says, Exhibit 22 is dated January 6th of 2023 with an approval date of January 13 of 2023. Okay. But during this hearing, Fanning testified he just wrote some reports last week, but backdated them. But the judge is giving them all the trust. In his report, Sergeant Bukhenik specifically noted, it was communicated to us during earlier interviews that Ana manipulated TW's iPad at TW's request prior to leaving the home on January 1, 2023. It would have further narrowed down the timeline for investigators to focus on in the search of the missing victim. Following their conversations, Sergeant Bukhenik gave Attorney Miner contact information for First Assistant District Attorney Lynn Beland FADA Beland. She's also a former assistant district attorney because she ran out of there so fast she left skid marks before the second Karen Reed trial. At the same time, David Traub also left the Norfolk district attorney's office. He was their PR guy or their mouthpiece. He ran out of there too. Following their conversation, okay, wait. So that their agreement could be memorialized as requested by Attorney Miner. Thereafter, Attorney Miner and First Assistant District Attorney Beland exchanged 3 emails between 3:39 and 4:06 p.m. Sergeant Bukhenik was copied on the 3 emails, which he attached to his investigative report. But remember, he testified that he didn't really read them. He didn't read them at the time, right? That's what I remember him saying. Correct me if I'm wrong. After Attorney Miner and FADA Beland emailed regarding the terms of the extraction and examination, footnote 9, which says, after memorializing the agreement with Beland, Attorney Miner advised her client about the terms of the agreement and told him that it was his decision. Brian decided to turn over the devices for extraction and analysis. So after Attorney Miner and FADA Beland emailed regarding the terms of the extraction and examination, Sergeant Bukhenik arranged for law enforcement to pick up the electronic devices from Brian at the Walshe residence. Well, you know what she didn't do in her decision? She didn't quote the email exchange. Christina, I can see you. You're not blocked. I can see you. You're here. I can see you. But I deleted that because it's distracting to me. I don't know. If not all your chats are going through, it's because you're trying to put words in there that I have blocked on this channel for good reason. So it depends on what you're trying to say. If you're trying to say some dirty, not that you would ever do that, some dirty nickname for Bukhenik, it's not going to come up. It won't show. We got rules for a reason. So there's that. So I'm going to show you the emails between Beland and Attorney Miner, and I'm going to let you decide what you think they mean. Because if you didn't see any other streams on this, you wouldn't have seen them. So for that, I have to go back to the original motion. Here's the email exchange. The email exchange was entitled Walshe Phone Search Agreement. And the first email is from Beland to Attorney Miner. Attorney Miner, as requested, the Norfolk District Attorney's Office agrees that in the investigation into Ana Walshe, any conversation between the attorney and client, Brian Walshe, is excluded from the search and examination of Brian Walshe's phone and TW's iPad. It is further agreed that any conversation between Brian Walshe and his wife, Ana Walshe, 1 week before she was missing, 12/25/22 and prior, shall be excluded from the search and examination of Brian Walshe's phone and TW's iPad. Should you have any questions, please contact me. Tracy writes back, we consent to all communications on or after 12/25. If you want to go back further than that, I will have to get you a list of attorneys as he has used a bunch of them. And then he goes, he quotes Yuri's report. This is Larry Tipton's motion. And he quotes what Bukhenik wrote in his report. Then I think there was one more email back where it said something like, okay, confirmed or something like that. To me, this indicates an agreement between two attorneys that they are looking for communications between Brian and Ana, or Ana and any other people for that 1 week period. It does not say anything about location data. It does not say anything about Google searches. It does not say anything about social media accounts. Your devices and your phones have your entire life on them. And that is why these agreements need to be made, and they need to be narrowed. I don't know. I learned in law school, written agreements always supersede oral agreements. And it is also important to note that the written agreement was the last thing that was done. Let's see the judge twist herself back into a pretzel to allow it. Because he was traveling to Washington, D.C. to further investigate Ana's disappearance, Sergeant Bukhenik and Lieutenant Fanning, the executive officer of his MSP unit, to pick up the devices. He asked him to pick them up. 2 cell phones and 1 iPad. Footnote 10. Lieutenant Fanning believes Sergeant Bukhenik told him to pick up 1 cell phone and 1 iPad, and I think that was the agreement. 1 cell phone and 1 iPad. I think there's some facts wrong in here, and I don't have time to go back and fact check everything in this 31-page decision, but I know that you guys have really good memories too. After speaking with Sergeant Bukhenik, Lieutenant Fanning called Attorney Miner, and she told him that he could go to the Walshe residence to pick up the electronic devices. In this approximately 5-minute call, Lieutenant Fanning specifically raised the importance of the child's iPad to the ongoing investigation, namely that because Ana had touched the device and fixed it for her son the morning of January 1 of 2023, determining the time that happened would narrow the search timeline so that law enforcement could properly target in on the surveillance of vehicles coming and going from the Walshe residence. In the 4 p.m. hour, Lieutenant Fanning arrived at the Walshe residence to retrieve the electronic devices. Lieutenant Fanning believed he was to pick up 2 devices, Brian's phone and TW's iPad. After introducing himself to Brian and explaining that he was there to pick up the electronic devices, Brian handed over his phone and TW's iPad to Lieutenant Fanning. Brian was very cooperative, cordial, and helpful. Lieutenant Fanning did not use a consent form because he was working cooperatively with Brian and Attorney Miner to obtain the devices and search them. Right? He didn't get a consent form because they already had a consent agreement in writing. And even he knew that that was supposed to govern, because the consent to search form is probably overly broad and says you're giving us consent to do a phone dump on your entire phone. I don't have access to the exhibit, so I can't see the blank one that they submitted. Before he left, Brian told Lieutenant Fanning that he had another iPad that the children used and that he wanted to give it to him. Brian retrieved that device and handed it to Lieutenant Fanning. This second iPad had a cracked screen. Lieutenant Fanning confirmed the passwords for the devices with Brian before he left the home and then returned to his vehicle. Inside his car, Lieutenant Fanning confirmed the password worked for Brian's phone. Inside his car, Lieutenant Fanning confirmed the password worked for Brian's phone, it says again, and checked the last text communication between Ana and Brian. I have another question, and I don't think this has been addressed here. Whose Apple account was logged into the kid's iPad? Anyone who has an iPhone and a MacBook and an iPad knows that you log in with your Apple ID and you can access all of your stuff on all of the devices. Whose Apple ID was logged into the kid's iPad? He's 6. I don't think he had his own Apple ID. Do you? Which means that if Ana Walshe for example, was somewhere else like Washington, D.C., and doing things on her phone, those things would also show up on the kid's iPad if it was logged, if she was logged in with her Apple ID, right? And I don't think this has ever been brought up. Never mentioned, right? What if it was the grandmother's Apple ID? What if the grandmother had logged in her Apple ID into the kid's iPad? And the grandmother was making searches like that from her house on her own phone. They could show up on that iPad too, right? And why has that ever been discussed? You can create a child's Apple ID, but would you for a 6-year-old? I don't know. But it's never been addressed. I don't know. Maybe they do, but I'd like to know the answer to the question rather than speculate. Wouldn't you? I would. So, moving on. Lieutenant Fanning returned to the Cohasset Command Center and handed over the 3 devices to Trooper Connor Keefe, an MSP forensic examiner who in turn brought them to the digital forensics lab of the Norfolk County DA's office. In Canton to perform the full data extraction and review. People were saying, why Canton? Because that's where the forensics lab of the Norfolk County District Attorney's Office is. To perform the full data extraction and review. Lieutenant Fanning also gave Trooper Keefe a piece of paper with the passwords written on it and instructed him that he had consent to download and analyze the data on the devices from January 25th, 2022 to the present. Once he arrived in Canton, Trooper Keefe met Trooper Nicholas Guarino and Guarino. Trooper O'Keefe was told and understood that Brian and Attorney Miner provided consent to extract and analyze all data from the 3 devices from December 25th to January 6th, 2023, footnote 11. Hang on a second. Footnote 11. This is like a game of telephone. And trust me when I tell you, maybe, in my opinion, this has been going on for decades. Coloring outside the lines, maybe not getting the proper warrants. And if it can happen to, people like Karen Reed and Brian Walshe, it could probably happen to you too. Footnote 11, the Gray Key Celebrite software allows the examiner to segregate and analyze only communications in the timeline feature. However, based on his conversation with Lieutenant Fanning, Trooper Keefe understood that he was permitted to extract and analyze all the data extracted in the agreed to time frame. Trooper Keefe understood that attorney-client protected communications in this case took place before December 25th of 2022. So, the judge is twisting herself into a pretzel to explain what Trooper Keefe understood from being told by Trooper Fanning, who was told by Sergeant Bukhenik, who had the actual agreement in writing, but nobody else looked at it, and their misconstruing of the written agreement and believing that the verbal agreement should govern. And all the verbal discussions were before the written agreement. To me, that's some creative sort of yoga. That's like contortionist type yoga. The Gray Key hardware and extraction software only allow 1 device to be extracted at a time. Trooper Keefe started the extraction of Brian's iPhone 13 mini, which took approximately 3 hours. He then started the extraction of TW's iPad 6 mini, and he went home. He went home, just left it there unattended, apparently. No big whoop, no biggie. Chain of custody in Norfolk County is not a thing. He went home. And then we get to January 7th of 2023. On January 7th of 2023 at 5:17 a.m., Sergeant Schmidt received a ransom email from Richard Walker 9984@gmail.com stating the following. We have the so-named Ana Walshe with us here. We had a deal worth $127,000. She messed up. We have her here with us, and if she doesn't pay the money, then she'll never be back. And we know that the police and the FBI are involved. Good luck finding us. Exhibit 6. Partial ellipses in original. Okay, that is the one thing that the judge wants to be very specific about, is that the ellipses, which are usually 3 dots, are only 2 dots. And she wants to make sure that we know that that is not a typo. The email contained no timeline to respond to the demand and no contact instructions. When Trooper Keefe returned to the Canton Digital Forensic Lab the morning of January 7th, 2023 at 10:30 a.m., he began the extraction of the cracked screen iPad 6. Okay, so he left at what time? Does it even say? He didn't get back there until 10:30 in the morning. So whatever time he left after extracting Brian's phone, that took 3 hours. Then he started on the mini, and then he goes back the next morning at 10:30 a.m. When you know anything, I know I thought that too, Rhonda. $127,000 is a weirdly specific, like the $118,000 in the John Benet Ramsey case. I thought the same thing. When Trooper Keefe returned to the Canton Forensics Lab the morning of January 7th at 10:30 a.m., he began the extraction of the cracked screen iPad 6. Trooper Keefe then loaded the data extracted from the 3 devices to the server, which was completed around 3 p.m. on January 7th of 2023. Was he there the whole time? Did he leave? Did he have eyes on it the whole time? We don't know. Footnote 12. Pursuant to the consent agreement. Oops, wait, that's not it. What's on here? Oh, wait. Footnote 12 says the event log time is reported in UTC, a coordinated universal time. The user must subtract 5 hours to convert the time to Eastern Standard Time. All information other than the evidence ID here, quote, Cohasset missing person, and the examiner name here, Trooper Keefe, are populated by the Gray Key software. So you got to subtract 5 hours in the event time log. Okay. Thereafter, at about 5 p.m., Trooper Keefe and Trooper Guarino, who arrived around 3 p.m., began reviewing the extracted data using Cellebrite Physical Analyzer, subject to the agreed to limitations, namely date limited to between December 25th and 2022 and January 6th. So Christmas Day and January 6th, the date of seizure, and excluding any attorney-client privileged communications. So they got the dates right. They just got the data wrong. They use Cellebrite, and they want us to believe that Cellebrite is accurate. Trooper Keefe was in the first floor lab reviewing the data from Brian's iPhone 13, and Trooper Guarino was in the second floor office reviewing the data from the iPad mini of the child. Both troopers were using Cellebrite to review the extracted data in the timeline view. In his review, footnote 13, which says, pursuant to the consent agreement, and these are the judge's words. I don't know why that's not going where I want it to. Trooper Keefe and Trooper Guarino used the timeline view to restrict their search to December 25th to January 6th of 2023. So they got that part of it right. They didn't get the part of just extracting the communications right, or just looking at the communications right, because they looked at everything. In his review, Trooper Keefe determined that Brian's phone had been unlocked 4 times in the January 1 to 2, 2023 time period. At some point after he began his review, Trooper Keefe received a call from Trooper DeChico. Trooper DeChico told Trooper Keefe that he had interviewed Brian sometime earlier that day, and Brian stated that on January 2nd, 2023, he had only been to Pressed Juice Bar in Norwell. Trooper DeChico asked Trooper Keefe if he could confirm that information. By looking at the native location data of Brian's iPhone 13 mini, Trooper Keefe was able to determine that Brian's iPhone had been in the area of Home Depot in Rockland, Mass. At 4:12 p.m. on January 2nd of 2022. This is where the fruits of the poisonous tree begin. Because if they weren't supposed to be looking at the location data of Brian's iPhone before they had an actual real search warrant, they looked at everything, Jessica. And that's how they got to the Home Depot, and that's how they got the surveillance video of Home Depot. Okay. DeChico said, oh, just take a little look-see at the location data. Let me tell you something. If all this stuff with Proctor hadn't blown up in the Karen Reed case, they may never have found this out. And it's because of Proctor and his shenanigans in the investigation into the murder of John O'Keefe and lying on search warrant applications. Like, for example, lying about what time the car was towed from Dighton in the Karen Reed case. Now, everything Proctor's ever touched comes into question. And Proctor used the Google searches in his search warrant applications in the PCA affidavit as probable cause to search the house and the car. Okay. It would have been an easy warrant to get. They didn't do it. They just did what they wanted to. Hold on one second. Fruits of the poisonous Proctor, somebody said. Trooper Guarino spent about an hour from 5 to 6 p.m. on January 7th, 2023, reviewing data in the timeline feature extracted from the iPad mini of the child. As he reviewed the data, Trooper Guarino first noticed searches on December 27th, 2022, relating to the best and worst states and places to get divorced. In the extracted data for the morning of January 1 of 2023 at approximately 4:55 a.m., he observed searches on how to get rid of or dispose of you know what. I got to be careful what I put up on the screen, so you may have to look at me for a few minutes while I read this to you. Okay? So that search on how to dispose of a person was made January 1 at 4:55 a.m. Now, Trooper Guarino continued to review data up to January 2nd of 2023 and observed numerous searches on person disposal, removal of smell, Cohasset dump, and cadaver dogs at the dump. At approximately 6:30 p.m., Trooper Guarino reported to Trooper Keefe what he had found in terms of concerning searches while reviewing the data from the kid's iPad mini. Trooper Guarino also reported his findings by phone to guess who? Detective Lieutenant Tully, who was in charge of Trooper Guarino's unit. Tully's everywhere. Trooper Guarino then created a PDF from the searches, which he emailed to Detective Tully and copied to Fanning, Bukhenik, DeChico, and Proctor. MSP decided that Trooper Guarino would stop his search of the information extracted from the iPad mini and seek a search warrant for the device, which was now back at the Walshe residence. Okay, why? Why would they tell him to stop and now look for a warrant, now get a warrant if they didn't think, if they thought he was allowed to look for that stuff. Why? I'm not a judge. I'm not a judge. I have decades of experience as a civil litigator suing such things and institutions as the Catholic Church for plaintiffs who were abused by priests. I have seen cover up and corruption at the highest level. At the highest level. Your Honor, why did Guarino decide to stop searching and go get a warrant if everything that he was looking at was within the scope of the consent agreement? Hello? And yet Proctor, because he's a dumbass who never had any, ramifications for his behavior before, used those searches that we can see by a reading of the facts here. Use those searches as probable cause to search the house and the car. Okay. It's called fruits of the poisonous tree. A tree is like a tree. It's got a trunk and it's got branches. And if you obtain evidence illegally in the first place, because, we have this thing called illegal search and seizure as part of the Constitution of the United States as such America. We have rights, certain rights. If the evidence is obtained illegally, any evidence they get after that, as a result of what they first got illegally, anything that results from that initial illegally seized evidence is called fruits of the poisonous tree. That is also supposed to be suppressed. I say supposed to be because we're in the land of the lost. We need Chaka. Where's Chaka? Here's Chaka. Sometimes we put Chaka in the corner to remind us that we are in the land of the lost. Your Honor, I think you just proved the fact that they knew that they were going outside the consent. Earlier in the day at approximately 2 p.m. on Saturday, January 7th, 2023, Sergeant Schmidt, DeChico, and Proctor went to the Walshe residence to interview Brian again, this time in the presence of his attorney, Tracy Miner. The interview lasted approximately 20 hours. 2 hours. I'm sorry, 2 hours, not 20 hours. Okay, so that was before the searches were sent to Tully. Same day. Okay. 2-hour interview. Brian's January 7th, 2023 interview was audio recorded, and a transcript which accurately reflects the interview was prepared. Footnote 14 says the audio recorded interview and transcript are in evidence, and both sides agree that they are a fair and accurate representation of the interview. This court has listened to the recording and reviewed the transcript, which the court concludes accurately reflects the contents of the interview. The court will not detail the entire contents of the January 7th interview, but will refer to the contents as needed herein. The parties agree that there was a dog barking in the background, and as with the other transcripts, background sounds are not included. Okay, here's a good point. Aaron says, some have questioned whether Brian made the searches or they were made once in MSP custody. Right. Some have questioned that. Brian stated that Ana used Instagram, Facebook, WhatsApp, Viber, and Venmo. Ana also used various banking and financial applications online to include Apple Credit Union, Liberty Bay, Fidelity, Chase, and JetBlue credit card. During the interview, consistent with the exclusion of privileged communications from the search of the electronic devices that had been turned over to law enforcement, Attorney Miner interrupted Brian to remind him not to discuss attorney-client conversations. Okay. Brian explained the protocol he undertook to alert federal authorities when he was leaving his home, which generally required 72 hours advance notice. If there was an emergency needed to leave the home, Brian was required to send an email to the federal authorities, and Attorney Miner granted permission to review those emails. So Brian was wearing an ankle monitor because of he had not yet been sentenced, I think, on his federal charges of selling the bogus Andy Warhol, paintings to somebody who was actually an Andy Warhol collector, believe it or not, for $80,000. And he was a con man, basically. He had some other charges too. He had stolen money from his father's estate, and there were some other things, some other things. that he had done that were, maybe fraudulent. I'm not aware of any prior history of violent crime that he had, but apparently the ankle monitor did not track his whereabouts, only what time he left the house. What's the point of an ankle monitor if it doesn't track your whereabouts? I don't know. Those were federal charges. I don't make the rules. As to his travels on January 1, 2023, consistent with information he provided in earlier interviews, Brian stated that he left his home to get milk and orange juice at Shaw's supermarket, returned those items to his home, and then went to his mother's home at 330 Paradise Road, Swampscott. Brian stated that he got lost on the way to his mother's home because he did not have his cell phone, which he typically used for directions. Once in Swampscott, Brian went to the Whole Foods and CVS for his mother. As to his travels on January 2nd of 2023, Brian indicated he went to get ice cream with his son in Norwell. Brian did not know anyone by the name of Richard Walker. That's the email. At some point during the interview on January 7th of 2023, officers returned to Brian the electronic devices he had provided to the police the prior evening. Well, Aiden Carney knows about this. And he still doesn't have his devices back. But they were able to give this guy his devices back within like 18 hours. So there's that. Brian stated that Ana used the chat function on the JetBlue app, there it is, to communicate with the airline, and if she didn't have her phone, would use an iPad. Miner added that she too used the JetBlue app. Okay, so Brian stated that Ana used Uber as her first choice and Lyft as her second choice, and that she would have used her phone to make transportation reservations. But again, I submit to you that if her Apple ID was logged into that iPad, they would have that, and that would be considered a communication, right? Communication with JetBlue. Location data is not a communication. Google searches are not a communication. Facebook Messenger messages could be a communication. Snapchat messages could be a communication, right? Instagram messages could be a communication. Contacting Lyft or Uber could be considered a communication. I would submit to you as well. Following Brian's interview, officers canvassed the neighborhood around the Walshe residence to look for footage of vehicles entering or exiting the property. Wow, can you imagine? They did that when Ana Walshe was missing. She was a missing person, and they did that. You know where they didn't do that? Oh, in the murder investigation of Officer John O'Keefe. They didn't do that then. At approximately 4 p.m. on January 7th, 2023, Lieutenant Fanning dispatched Trooper Kowski, and she spells it wrong. She spells it Kokowski, but we know it's Kotkowski because he's been around a lot in a lot of the cases that we've covered. At approximately 4 p.m. on January 7th, Lieutenant Fanning dispatched Trooper Kowski, Sergeant Panazelis, Trooper Gobranson, and Trooper Sullivan to Swampscott for the purpose of confirming Brian's stated whereabouts on January 1, 2023. Specifically, Trooper Kokowski was dispatched to the CVS in Swampscott, and the 3 other officers went to Whole Foods in Swampscott. Sometime between 6 and 7 p.m., Lieutenant Fanning learned from the dispatch officers that video surveillance did not show Brian at the CVS in Swampscott or another nearby CVS, nor did it show that he had been to Whole Foods in Swampscott. In addition, CVS informed officers that the items Brian stated he had purchased at CVS had not been sold to anyone in the time frame indicated. Well, I submit to you, Your Honor, based on that, they might have been able to get a warrant for the location data because he lied to us. He's misleading the police. We went there. He said he was there. He wasn't there. Give us a warrant for the location data on his phone. But no, they didn't do that because why should they? They never have before. Why would they do it now? With this information in hand, by the evening of January 7th, 2023, MSP believed Brian had provided false information to officers regarding his whereabouts on January 1 of 2023. Based on the totality of their investigation, to include the suspicious search history discovered by Trooper Guarino, which again, I submit to you is outside the scope of the consent, MSP sought and obtained a search warrant for the Walshe residence. So let me explain the fruits of the poisonous tree again. If the search history was obtained illegally and outside the scope of the consent, and Proctor used it in his affidavits for probable cause to get the search warrant for the house, anything they found inside the house, if it was found the searches were illegally obtained, should also be tossed. But let's contort ourselves a little bit more, because they're lazy. They could have obtained a warrant for the phone, but they just didn't. So I submit to you this. If we say the search history is fruits of the poisonous tree, would the information that Brian Walshe was not seen at 2 CVS's and a Whole Foods in Swampscott be enough probable cause to search the house? Let's see what the judge has to say about that. Here she says, even without the suspicious search history uncovered by Trooper Guarino, MSP would have sought a search warrant of the Walshe residence, less the physiologic evidence. Well, that's blood, isn't it? It's blood. What else did they find in the house? Found blood. Found some stuff that he bought at Home Depot, maybe. And instruments of the crime. Okay, so you're saying, Judge, that even if you did throw out the search history because it was obtained illegally, they would have sought a search warrant of the house, but they wouldn't have been able to get instruments of the crime, which is, you know, weapons or hacksaws and physiological evidence like blood and fluids and other things. Body's never been found. Now we get to January 8th of 2023. On January 8th of 2023, Trooper Keefe continued to work on the data analysis for Brian's iPhone 13. Again, we find out later, or we know they didn't get a proper search warrant for that phone until the 9th. So Keefe is still at it. He's still doing all the data analysis on all of the things and stuff from the phone. Specifically looking at the native location data for the time period January 1 to January 6, 2023. Based on his review of that native location data, specifically GPS points, Trooper Keefe contacted Lieutenant Fanning to ask that officers be sent to Claremont Apartments in Abington, the Point Apartments in Abington, and the Chatham West Apartment in Brockton to retrieve surveillance video for certain time periods in an attempt to find Ana. I mean, again, why did Guarino stop searching? Let's see, where are we? On January 7th, he stopped searching, all right? And decided they were going to get a warrant. But during this time, she's very unclear about this. Okay, so he spent an hour from 5. So we're going to say like at 6 p.m. That's when he said, I'm stopping and I'm going to get a warrant. Okay. But then we have Connor Keefe at the same time the next day. That was January 7th, right? I'm being so gaslit right now. That was January 7th. But they didn't get the warrant. And then on January 8th, Keefe is still looking at the location data. Do you see what's happening here? Guarino says at 6 p.m. on the 7th, let's stop. We need a warrant because they see some suspicious searches. They don't get the warrant. And then the next day, Trooper Keefe gets in there and continues to do the location data. I don't live in Massachusetts. I ain't got no dog in this fight, but I'm a constitutionalist and I believe in rights for all. And this ain't good. Agreed. The Norfolk DA's office is as much to blame as the MSP. They allowed this illegally searched evidence in to get the charges. Here's the other thing. Mark Betterill points this out all the time. Why are the troopers getting search warrants? Why is Michael Proctor drafting his own probable cause affidavits? It's not the way we do it in New York. In New York, the DAs draft the affidavits. The troopers, the law enforcement signs them, and then the DA has all the warrants in his file. Remember Lally the other day on the stand, like, oh, I don't know, I had these warrants, at the grand jury, and then, then I just never turned them over. Why? I really don't know. I just never followed up. I don't really know. New Jersey Robin says, Melanie, hold on a second here. Oops. We do not really know what Miner said on the stand. She was also friends with Ana, so what she said on the stand could be why the judge made the decision. I don't know. We don't know. Can we get the transcript of what she said on the stand? Anybody have FTR? I'll pay for the transcript if somebody can get it. Thank you. That's not the way they do it in Massachusetts. In Massachusetts, troopers write the search warrant applications. They just get them and then they just put them in a drawer somewhere. So on January 8th, here's Trooper Keefe. He's going for the location data. Based on his review of that native location data, specifically GPS points, Trooper Keefe contacted Fanning to ask that officers be sent to all of these places to retrieve surveillance video for certain time periods in an attempt to find Ana. On January 8th, between 8 and 9 a.m., an MSP and Canton PD officers arrived at the Walshe residence to execute the search warrant. When they arrived, Brian, his mother Diana, and the 3 minor children were the only individuals at the home. Once the scene was secured, Lieutenant Fanning called Attorney Miner to inform her that they were executing a search warrant at the Walshe residence. Footnote 15. During the search, officers seized multiple electronic devices, 3 MacBooks, an iPhone 13 mini, an iPad 6 mini, a cracked screen, iPad 6, another iPad, and an iPhone SE. Well, it's important to note that they seized the devices that they already returned to him again on the 8th. But they still didn't have a proper search warrant to examine the devices. Dun, dun, dun. Attorney Miner arrived about 15 minutes after the call and facilitated the defendant and his family going to her nearby home while the police performed the search of the Walshe residence. Footnote 16 says, Attorney Miner testified that she was at the Walshe residence when the police arrived to execute the warrant. The court does not credit this recollection. The court does not believe the attorney's testimony that she was there when the police got there. As an officer of the court, attorneys under oath are sworn to tell the truth. You could get disbarred for lying on the stand. But this judge just doesn't believe the attorney. It's wild. I've never seen anything like this. At approximately 11:30 a.m. on January 8th, 2023, Sergeant Schmidt, Trooper DeChico, and Trooper Proctor went to Attorney Miner's home to interview Brian in the presence of his counsel. So this is 11:30 a.m. on the 8th. They're searching the house. Schmidt, DeChico, and Proctor go to the attorney's home to interview Brian there in the presence of his counsel. This interview lasted just over 10 minutes and was audio recorded and transcribed. Footnote 17, the audio recorded interview and transcript are in evidence, and both sides agree that they are a fair and accurate representation of the interview. The court has listened to the recording and reviewed the transcript, which the court concludes accurately reflects the contents of the interview. The court will not detail the entire contents of the January 8th, 2023 interview, but will refer to the contents as needed herein. The police asked Brian about his use of the iPad, and he indicated that he used it to put spooky movies for the children on. The interview was terminated by Attorney Miner when police inquired about searches relating to the getting rid of the human body. I got to take this down again because, strikes and all. I mean, demonetization, unfriendly to advertisers, blah, blah, blah. Let's put Proctor up in the corner. A recent picture of Proctor. See, we used to have this one, but Proctor's had a glow down, and now he looks like this. To remind you of all the shenanigans, tomfoolery, and ballyhoo that he has been involved in with so many cases. I want this guy convicted too. If he did this, Candy Heart, he has children and they should never be near him. I agree. But it's a problem when district attorney's offices and law enforcement reverse engineer cases to suit their narrative of who did it. And then the judge makes an excuse. Well, the guy's probably guilty anyway, so I'm not going to suppress any of the illegally obtained evidence. That is where I have the problem, right? It's quite a conundrum, as Laura McLaughlin said in court on Thursday. A conundrum. The interview was terminated by Attorney Miner when police inquired about searches relating to disposal of a human body and body decomp on TW's iPad 6 mini in the early morning hours of January 1 of 2023. At approximately 4 p.m. on January 8th of 2023, Lieutenant Fanning, Sergeant Schmidt, and others returned to Attorney Miner's home and placed Brian under arrest. Well, it's important to note. So that was 11:30. They go for a 10-minute interview. They start asking about the searches. Then at 4 p.m., they go back to the home. Well, I guess they're still searching the house, and they arrest him. They didn't have a warrant for the phones until the 9th. Keep that in mind. Yeah, that's an interesting point, too. Did he not have safe search on for his kids at all, says the right meow? That's a good point. I assume not. Huh. And here, the judge goes into the rulings of law. Voluntariness and scope of the consent. Now, who in the chat can tell me? Oh, I could use Pig Latin. I could try that. Rder may. Yeah, there you go. We can do that. Who can tell me when the first iPhone came out that it became, like you could do everything on it, not just text, like internet, Google searches. What year was that? Because I remember having a car phone. I remember having a car phone in in the 90s, and it was hardwired into my car. It had a giant receiver. Like you would pick it up. It was like an old fashioned phone receiver, but you couldn't take it out of the car. It was like hardwired into the car. That was I don't know, mid 90s. So when did we get the iPhone in our pocket where it had everything? Like around 2008, 2009, around there, where it had the internet on it and everything. Okay, so keep that in mind while we go through the case law here that the judge cites. Voluntariness and scope of the consent. A search may be conducted without a warrant, provided it is undertaken with free and voluntary consent, citing a U.S. Supreme Court case from 1973. But a search that is based on consent may not exceed the scope of that consent, citing Commonwealth v. Ortiz, 2018 case from Massachusetts. The Commonwealth has the burden of demonstrating that the defendant's consent was freely and voluntarily given, and not as a result of being coerced or as a way of acquiescing to a claim of lawful authority. Footnote 18. The defendant argued at hearing that the Commonwealth must prove consent beyond a reasonable doubt. In his written pleadings, the defendant provides no case law to support this standard. In fact, the case law refers to the preponderance of the evidence standard applying to consent searches. See U.S. v. Matlock from 1974, Commonwealth v. Ware from 2009, citing Commonwealth v. Walker from 1976, quoting from Bumper v. North Carolina from 1968. The test for whether a consent is voluntary is totally subjective, focusing on the particular individual rather than on a hypothetical person. U.S. v. Lewis, 1990 case. See Commonwealth v. Egan, 1981. As to the scope of the consent, the standard is that of objective reasonableness. What would the typical reasonable person have understood by the exchange between the officer and the suspect? 1991 case is cited there. Quote, the focus is solely on what a typical reasonable person would understand the scope of consent to be, based on the totality of the circumstances, including the words spoken and the context in which they are spoken. More specifically, what would the typical reasonable person have understood by the exchange between the officers and the consent giver? Like, are we forgetting that there was a writing drafted after the conversations with law? This is where she's losing me. I'm feeling gaslit again. You might have to talk me off the ledge. To determine objective reasonableness, this court looks beyond the language of the consent itself to the overall context, which necessarily encompasses contemporaneous police statements and actions. Citing U.S. v. Turner from 1999. The scope of a consensual search is generally defined by its expressed object. Quoting Jimeno. See Commonwealth v. Hines from 2002. Court must evaluate all circumstances to determine whether a reasonable person would be warranted in belief that consent giver placed some limitations on the search. The defendant first challenges the voluntariness of his consent to the search of certain electronic devices, largely in his written motion. He argues that the police misled him by telling him that they were investigating a missing person in the context of the police's community caretaking function, when in fact they were targeting the defendant. The Commonwealth counters that it was abundantly clear that the investigation intended to verify Brian's whereabouts as part of their investigation, citing the defendant's third recorded interview, in which the police told Brian that they intended to develop a timeline of his whereabouts because of public suspicion. Brian's responsive acknowledgement that his attorney had already prepared him for that, and Attorney Miner's comment to police, quote, thank God for the ankle bracelet, as it would have his location data for January 1 to 2 of 2023. Well, did Tracy Miner, she might not have known that the GPS ankle bracelet did not include actually where he was. Viewing the circumstances of this case in their totality, and after careful review of the 4 recorded interviews, this court concludes that the Commonwealth has met its burden in demonstrating that the defendant's consent was voluntary. Commonwealth v. Harmon, 1978, enumerating common factors, including the lack of knowledge of the right to refuse consent, intoxication or influence of drugs, physical injury, lack of prior arrest, mental or emotional state, age, education, intelligence, maturity, and whether the individual was under arrest. Court should consider in subjectively determining whether defendant's consent was voluntary. There was no evidence of coercion. Well, I agree with her. I think it was a voluntary consent, but I think the consent was limited. Let's move on. The defendant not only repeatedly indicated his intention to do whatever was needed to assist the police in finding Ana, but he was given the time to consult with his attorney and thereafter turned over his cell phone and 2 iPads. Right. Before he turned over the devices, Attorney Miner explained his rights to him, which evidences knowledge of his right to refuse consent. While Brian may have been upset that Ana was missing, tired from the police questioning, and at times distracted by his young children, these factors did not invalidate his consent. Citing a case from 1991. In addition, there was no trickery employed by law enforcement here. As Trooper DeChico stated to Brian in his 3rd recorded interview, ironing out a reliable timeline for Brian would help the police address any public suspicion and benefit both Brian and the police. C, Colorado v. Spring 1987 case, which says consent not rendered invalid when the police do not disclose everything that they might have in mind in seeking it. Well, I would distinguish this case by saying that Lynn Beland, Tracy Miner entered a written consent agreement. Next, the defendant challenges the scope of the search, arguing that the Commonwealth exceeded the parties' agreement as to what would actually be reviewed. Okay, this is where it gets important. Specifically, the defendant argues that while he consented to and knew that law enforcement would do a full data extraction of the 3 devices, the agreement he entered into with the Norfolk County District Attorney's Office would allow law enforcement only to look at communications between Brian and other people, excluding communications with Attorney Miner in the period between December 25th, 2022 and January 6th of 2023. Footnote 19. Oops. Hold on. Which says, there is no dispute that the parties agreed to search time frame was December 25th, 2022 through January 6th, 2023. The Commonwealth counters that it did not exceed the agreed to consent and that the parties' agreement did not restrict it to looking at only communications between the defendant and other people. Rather, according to the Commonwealth, the only exclusion from the search in the agreed to timeframe was communications between Attorney Miner and the defendant. As noted, the court's inquiry is as to what the typical reasonable person would have understood by the exchange between the officers and the consent giver based on the totality of the circumstances. Viewing the entire exchange between Detective Schmidt and Trooper DeChico with Brian on January 5th, and that between Sergeant Bukhenik and Attorney Miner on January 6th, a reasonable person would have understood the search as including all data extracted in that date range. I disagree. I strongly disagree. She's saying, I believe Bukhenik more than I believe Attorney Miner. December 25th to January 6th, excluding only attorney-client communications between Brian and Attorney Miner. The first interview that took place, where officers requested Brian's consent to search his phone, occurred on January 5th of 2023 between Trooper DeChico and Detective Schmidt and Brian. Trooper DeChico made clear that the officers were asking for consent to download the entire phone. Although he stated that police were interested in seeing the communications between Ana and Brian, hang on a second. I have some questions that I'm going to star for later. So if I see them passing through, I will star them for later. Although he stated that the police were interested in seeing the communications between Ana and Brian, Trooper DeChico also explained that police were interested in locating Ana and finding the information specifically in the phone that would help them do that, the Ana-specific content. Here's another reason why this is chilling, and I'm going to say it now so I don't forget to say it later, is that this decision is kind of making it clear that a defendant's not allowed to change his mind about his consent, right? After talking to his attorney. And I don't agree with what she's saying here, because I think that DeChico was like, no, there's no crime. We're just looking for, to see the tone of your communications with Ana. We're just looking for communications. This decision is telling everyone who lives in Norfolk County and maybe even in the state of Massachusetts that even if you give consent at one point verbally, you can never change your mind later on in a writing. Because this judge is saying, we're going to go all the way back to all the conversations you had before and look at the totality of all of those conversations that you had with law enforcement. And you might have said, yeah, hey, here you go. Look at everything. I just want to find my wife. Take it. And that you can never change your mind later before they actually seize your phone. And that the agreement between attorneys in the district attorney's office and defense attorneys are worth nothing. They're not worth the paper they're printed on. Doesn't really matter what you said in your written agreement after the verbal conversations with law enforcement when you weren't there, counselor. Doesn't really matter what your written agreement says, because we're going to take everything that the troopers say happened and the written, the the recordings of those, because, thank God they recorded these interviews. It's a problem. Be afraid. Be very afraid. Brian's acknowledgement of the huge amount of personal information they were requesting signaled to police that he understood the breadth of information they were seeking. Right. And didn't he also say in that conversation, I got to talk to my attorney. And if my attorney says only for certain things that you can only get certain things. I'm being gaslit at the highest level. Sergeant Bukhenik spoke with Attorney Miner about the request for consent to the digital extraction multiple times on January 6th of 2023. And remember, didn't he say, I didn't write down my conversations or something? I didn't take notes. I don't remember when they were. I don't even remember. I have to go back and watch it. He also made it clear that law enforcement wanted to do a full system extraction of the phones. Attorney Miner suggested, and Sergeant Bukhenik agreed, that the search would be limited to dates between Christmas and January 6th and would exclude her attorney-client communications with Brian. To the extent Attorney Miner intended the search to also be limited to only Brian's communications with others in that time period, she did not directly or indirectly communicate that to Sergeant Bukhenik by stating as much or inquiring whether police could extract only communications rather than the entire phone contents. And we're trusting Yuri instead of an attorney. She may not have had those conversations with him. She may have had them with former First District Attorney Lynn Beland, who is somewhere in the wind and was not called to testify at this hearing. She further agreed that Brian would also turn over the child's iPad, a device which she knew did not contain any communication between Brian and others. Right. But they were looking to find out if Ana got on a plane. And so they might have been looking for the JetBlue communications again. During police interviews, troopers made repeated references to their interest in and the timeline importance of determining whether Ana fixed TW's iPad the morning of January 1, 2023. And there was a clear indication that they desired to look for information to pinpoint the exact time that happened. Trooper Fanning expressed the same sentiment to Attorney Miner during his phone call with her about picking up the devices. She did not inquire as to whether police could extract only communications rather than the entire phone contents, and neither she nor Brian ever questioned why the police were requesting consent to search TW's iPad when the device did not contain any communication between Brian and others. I am being so gaslit right now. As an attorney, I can tell you that my conversations about those material terms of an agreement would be had with the other attorney, not Fanning. Right? My God, man. If it was indeed their understanding that police only sought communications, there would have been no need to turn over the iPad at all. Forgetting about the JetBlue chat again. Moreover, given that Attorney Miner stated that she did not like to give the government anything, it would make little sense that she would agree to turn over 2 iPads that contained no communications if, in fact, the scope of consent was limited only to communications. Now she's saying that it makes no sense what the attorney did, what Tracy Miner did. Is she trying to help Brian Walshe set up an ineffective assistance of counsel argument at some point? And trying to help and prevent the MSP usual characters from any more trouble that they could possibly be in? This is so bizarre. And she cites a 2010 case, Commonwealth v. Farnsworth, that says police justified in believing there was no limitation on consent to search entire home based on a consent giver's words and actions. Well, I would argue that a home is different than a phone, right? Additionally, Brian repeatedly expressed his intention to assist in the missing person investigation in any way possible, offering up his cell phone during the interviews for the police to view and voluntarily handing over another cracked screen iPad used by the kids. Quote, applying a common sense interpretation to the exchanges between the officers and Brian and between Attorney Miner and Sergeant Bukhenik, it was objectively reasonable to conclude that the consent to search included all data on the 3 devices that could be extracted to assist in finding Ana, as that was their primary focus in the then missing person investigation. Okay, here's a case, Commonwealth v. Fensher. Court applying a common sense interpretation to the entire exchange between defendant and police detective found, quote, it is objectively reasonable to conclude that the defendant's consent to search her cell phone was free, voluntary, and unlimited. Well, I wonder if in Commonwealth v. Fensher from 2019, if that defendant signed a consent agreement, like the form that they gave Jennifer McCabe when she turned over her phone, or if there was a different writing between the attorneys. The defendant argues that Attorney Miner negotiated the scope of the search with the Beland and that their agreement only concerned communications on the devices. However, Beland merely memorialized the already agreed to terms of the consent agreement between Sergeant Bukhenik and Attorney Miner. Hold on. I pulled this up on my other screen right now, the email exchange. Nowhere in the email from Lynn Beland does it say, this will confirm your conversation with Yuri Bukhenik and incorporate all terms that you agreed to verbally. And also this. No, it doesn't say anything about any conversations with Bukhenik. Beland's email noted that any conversation between the attorney and client Brian Walshe and any conversation between Brian Walshe and his wife Ana Walshe on the week before she went missing and prior shall be excluded from the search and examination of Walsh's phone and TW's iPad. Attorney Miner responded, quote, we consent to all communications on or after 12/25. If you want to go back further than that, I will have to get you a list of attorneys as he has used a bunch of them. Nothing in this exchange limits the search and examination of the phone and iPad to only communications. Really? Really? It is the only thing that is even discussed in this exchange is communications. It's the only thing discussed. Please, am I crazy? You can tell me if you think I'm wrong and I'm crazy. If you think this could be interpreted to say, have everything you want, except for communications before December 25th with Ana and Brian and any attorney-client privilege communications. Just, tell me. Rather, the emails refer to the exclusion of communications subject to attorney-client or marital privilege, material that typically would be excluded from the search of a device capable of containing such communications. Given the content of the email exchange, noting only what should be excluded from the search of the phone and iPad, along with the previous discussions about the extraction of all the data, previous discussions, that's important here. A typical reasonable person would not have understood the emails to be limiting the search to just communications. I mean, I consider many of you in the chat to be typical, reasonable people. Tell me what you think about that. You are typical, reasonable people. Would you have understood the emails between your attorney, if you were the defendant, and the Lynn Beland to mean only communications? You're reasonable. Put a 1 in the chat if you think that the email agreement between the two attorneys referred only to communications that they were allowed to search. Put a 1 in the chat because you're a reasonable person. And if you're a reasonable person who says no, I think that was the only things they were excluding and they were good. They wanted everything. And I consented to everything. Put a 2 in the chat. A lot of 1s in the chat. There's a two in there. And that if you were the defendant, you would think that you were giving them anything on your phone, your banking information, your Google searches, your cringe and fumble logins, and whoever you've been communicating with on the dating apps and Grindr. What else you do? I don't know. You're all reasonable people in my mind. The defendant also contends that at the very least, the scope of the agreement was ambiguous, and that ambiguity should weigh in favor of the defendant and against the Commonwealth. Well, I would agree to that as well. It is certainly true that, quote, the requirement of reasonable clarity applies to the scope of consent, and that if the court is unable to discern the scope of consent because the agreement was ambiguous, then the search should be deemed unlawful. Oh, see Ortiz v. Massachusetts. However, the scope of consent in this case was not ambiguous. The police explained in no uncertain terms that they were performing a full data extraction of the devices and looking for information to assist in locating Ana. They explained their intent to create a timeline using data showing the last time Ana manipulated the iPad. The discussions about limiting their search only concerned communications subject to attorney-client privilege, and those between Brian and Ana before December 25th, and the actions of the police, Brian and Attorney Miner, reflect an agreement to consent to a search of the phone and iPads for any information in that time frame that could assist with locating Ana, excluding only the aforementioned communications. I'm trying to look at it the other way, and I just can't get there. I just can't. Because I think the judge might have been able to make a much stronger argument for inevitable discovery than doubling down for 28 pages that they were within the scope of the written consent, and that everything that they discussed should also be considered, even though it was before he spoke to his attorney. I feel like I'm repeating myself a lot, so I'm sorry if I am, but this is how important this is. Even if Attorney Miner believed that she was consenting to a search only of communications in the devices, the court's inquiry here as to what a typical reasonable person would understand the scope of the consent to be, based on the, quote, totality of the circumstances. I got to read this sentence again because it didn't make sense to me. Even if Attorney Miner believed she was consenting to a search of only communications in the devices, the court's inquiry here is as to what a typical reasonable person would understand the scope of the consent to be. Oh, so you're saying that Tracy Miner, the attorney, is not a typical reasonable person? Based on the totality of the circumstances. Based on the overall context of the encounters with the police in this case, an objective observer would not perceive the search as exceeding the scope of the defendant's consent. I don't know how much more strongly I can say that I 29 pages. Cops lie all the time, says Metal Chem 3R, yeah. And then when you have a written agreement, shouldn't that be? Rainy Day says, yes, the judge is spot on. You have to look at the totality of the circumstances. Yeah, but I'm saying that all the conversations that happened with Brian Walshe and law enforcement were outside the presence of his attorney. And they were before Lynn Beland and Tracy Miner entered into a written agreement. It's my opinion. Whether I think Brian Walshe is 100% guilty or not, all they had to do was get a proper warrant to search the phones, and we wouldn't be here. That's all they had to do. And they didn't do it because they're lazy. And here's inevitable discovery. And here's the judge's reasoning on inevitable discovery, which she only talks about for one page. Even if the Commonwealth exceeded the scope of the agreed to search of the electronic devices, the exclusion of the evidence is not automatic. Commonwealth v. De Jesus, 2003. Quote, evidence need not be excluded under the, quote, fruit of the poisonous tree doctrine, even if the government misconduct was a cause in fact of the discovery of the evidence. If the government obtained the evidence through an independent source, if the connection between the improper conduct and the derivative evidence has become so attenuated as to dissipate the taint, or if the government can demonstrate that the evidence inevitably would have been discovered by lawful means. Commonwealth v. McAfee, 2005, quoting Commonwealth v. Fredette, 1985. In this case, the challenged searches and location data would have been inevitably discovered during the execution of the search warrant at 516 Chief Justice Cushing Highway, Cohasset, during which law enforcement would have seized the defendant's cell phone, TW's iPad, and other electronic devices in the home. I'm going to remind everyone, Proctor's probable cause affidavit to get the warrant to search the house relied on the Google searches. Okay. Quote, the inevitable discovery rule under Article 14 requires a two-step analysis which focuses first on the question of inevitability and second on the character of the police misconduct. Citing a case from 1990, McAfee, it's the Commonwealth v. Perot, 1990. The Commonwealth has the burden of proving the facts bearing on inevitability by a preponderance of the evidence, and once the relevant facts have been proved, that discovery by lawful means was certain as a practical matter. The severity of the constitutional violation is critical in deciding whether to admit evidence that it is shown would inevitably have been discovered. 1989 case. Quote, bad faith of the police shown by such activities as conducting an unlawful search in order to accelerate discovery of the evidence will be relevant in assessing the severity of any constitutional violation. Here, even assuming that the police exceeded the scope of the consensual search, after striking the references to the internet searches and location data discovered during the search of the full extraction of the two devices, the information remaining in the search warrant affidavit provided probable cause to believe that the defendant misled the police in its investigation into Ana's disappearance, and that electronic devices that contained the evidence of the same would be found in the Walshe residence. This includes Brian's false statements about his whereabouts on January 1 of 2023, the 6-year-old son's account of when Ana last touched his iPad and left the home, Brian's account of why he did not contact police to report Ana missing, and his subsequent communications to Ana and others about the disappearance when he found his phone, and information concerning the return of Brian's iPhone and TW's iPad to the home on January 7th of 2023. The terms of the warrant would have authorized the police to search for electronic devices in the home, particularly those known to be manipulated by Ana and or used by the defendant. Thus, discovery of the electronic searches and location data was certain as a practical matter. Okay. Even if they got a valid search warrant to search the home and they were able to search those seize those devices again, they still need warrants to search the devices. Who knows how long it would have taken to get a warrant to search the devices? The reason they got all the video, all the surveillance video from Home Goods, Home Depot, the dumpsters. The reason they got all that surveillance video is from the location data. We have learned from the Karen Reed trial that sometimes video overwrites itself, certain systems, right? So by the time they got a proper search warrant, would some of that video have overwritten itself and not have been available to the police? Maybe, right? And if he lied to you about his whereabouts, why didn't you just go get a warrant to say we need to get the location data off of his phone? What if, like Brian Higgins, he cracked his SIM card in half and then disposed of his phone before the police were able to search it? Then what? I don't know, but I got problems with this decision. Next, turning to the severity of the constitutional violation, again, presuming for purposes of this analysis that the government's examination exceeded the consent given, there is no indication that the police acted in bad faith to accelerate the discovery of the evidence through an unconstitutional shortcut. No, they're just lazy. Because both prongs of the inevitable discovery rule are satisfied, there's no reason to suppress the searches or the location data. Right. And Kristen points this out too, and I'm not sure 100%, but he didn't end up lying either. Didn't they go to the wrong stores? I think they did go to the wrong stores. And also, they found the Lowe's receipt in the Volvo, as they call it, the Volvo. They found the Lowe's receipt in there during the consensual search. So there was a receipt from Lowe's. Did they ever get any surveillance video from Lowe's? Because that would have been fine. That would have been fine. It was Home Depot and the Home Goods, right? Where he bought the rugs and the cleaning supplies and the hacksaw and the hatchet and the cleaning supplies and the buckets and the mops and the things. I don't think those were from Lowe's. So I don't know. Order. For the foregoing reasons, it is hereby ordered that the defendant's motion to suppress information resulting from the search of electronic devices based on consent, paper number 78, is denied. XOXO. Diane Freniere, Justice of the Superior Court, dated July 25th of 2025. That was filed yesterday, like in the afternoon. Always on a Friday, right? And interestingly enough, the day after the hearing on the motion to dismiss, which we watched together on Thursday. And I was thinking to myself, oh, I guess she's not going to grant the motion to suppress because she's really digging deep into the other things that they went into in the motion to dismiss. Tyvek suits. Let's go to the chat and see how you're feeling about this. Sarah Be Creative has been here for 1 year and says it's our happy 1 year anniversary to us. Happy 1 year anniversary to us. Yay, Sarah. Joanna says, dancing in my kitchen. You've been here for 12 months too. Joanna's an OG. Jenna became a member. Welcome. Good morning, Mozzie in Australia. It's 2 a.m. in Oz and Mozzie's up for it. Mary Fitz says, bull. Alice is here from Poland. She's been here for a year and says, it's evening here in Poland. And it is morning in Kansas City, says Dr. Turtleboy was right. Ciao Bella. Ciao Bella became a member. Thank you. Thanks, Kaylee Paralegal, for your super sticker. Madeline Wag says, thanks goodness for you, Melanie. You've been the biggest gift to us. Always so smart and helpful. We are so lucky for you. Please don't ever leave us. Aw, thank you. That's very, very, very sweet. And thanks for your super chat. And Gigi says, anyone who watches you and are worth the greatest salt know that you do not play in their games. We love you. Thank you. Appreciate that. And oh, look at Gigi. Gifted 10 memberships. She's awesome. Welcome to the 10 new members. Welcome to the 10 new members. This judge knows without those searches and without that video, they don't have a case. So I thought she twisted herself in a pretzel to keep it all out. No longer watching the OnlyFans says, bad call by judge, letting the cops get away with it. Greg says, so a written agreement between attorneys doesn't mean anything to certain judges. It is correct. I see somebody saying Plymouth County is now the new Norfolk County, but this case is actually a Norfolk County case. It is being heard by Judge Freniere, who happens to be sitting right now in Plymouth Superior. And so when the trial comes, it's going to be in Norfolk County. So, don't know. But I see what you are saying. The love of the traveling trooper says, I'm so disgusted. No one ever has accountability. No, they don't. Charles Argo says, did the boyfriend ever report Ana missing at work? I don't think so. I think it was, maybe the boyfriend was the one who alerted the head of security. And then the head of security is the one who notified Brian, because Brian said, listen, she didn't come home on Christmas. She missed her flight and then she drove home. Same thing happened on Thanksgiving. It turns out that she was with her paramour in Dublin for Thanksgiving, by the way. So he said, Brian said, she got mad at me. I didn't want to call her work to find out where she was because I hadn't heard from her for a couple of days, but this wasn't uncommon because it had happened a lot. The boyfriend might have called head of security at, I think Tishman Spire is where she worked, right? So I don't know. Do not know. Thanks, Charles. eBay Warhol says, so lesson learned, if they ask for your phone, the answer is get a warrant. Yeah. And if he did search all of those things on the son's iPad, I submit to you, why would he just hand it over? Why would he? Right? eBay Warhol says, you always say, don't ask a question you don't know the answer to. That is right. Jojo says, so all roads lead to ... Jojo also says, I'm being so gaslit by the fruits of the poisonous tree to the point I'm just randomly singing Mad World. Yeah, it is a mad world, isn't it? Thank you, Karen, for becoming a new member. And Jeannie Emerald Gray says, preach, Melanie. Rescue to the land of the lost. Love rescue to the land of the lost. Thank you. And Amber's been here for 20 months. 20 months. Gigi says, these clowns are about to get as sharp as a bowling ball. Noelle says, you go all shining and say red rum. And I just don't like it. I don't know why. I just don't like it. I could. I just don't like it. Thanks, Noelle. Gigi says, these so-called decorated cops should have thought about the same amount of decorations that were on Charlie Brown's Christmas tree. If you know, you know. Yeah, one little ornament on Charlie Brown's Christmas tree. Tara says, I wonder if they did an alcohol or drug test, because if I'm Brian, what's stopping me from saying I was under the influence when I gave verbal consent? I don't think they did. I mean, maybe when they got him into custody, they might have, but they did not do one when he gave consent that I'm aware of. But it's a good point. Thanks for your super chat, Tara. No longer watching. The OnlyFans says, like, I get this guy's probably guilty as F, but this is just a terrible ruling and just telling the MSP that their behavior is okay. It is not. Yes, you're correct. That is exactly what it is doing. It is validating their behavior. This is the reason, in my opinion, why they don't get proper search warrants and why they do whatever the hell they want, because they've never had any ramifications for their behavior. None. Never. Why should they? Greg says, detectives to judge. No news yet. eBay Warhol says, I'm a reasonable person and I still don't understand the totality of the circumstances. It means you consider everything surrounding, right? So she's saying that we have to consider everything that happened, all of the totality, not just the writing between the attorneys. We need to consider everything, all the conversations that Bukhenik had with Brian Walshe and all of the verbal agreements that they had, not just the written agreement. That's what she's saying. The totality of the circumstances, all of it, everything all together. Brad says, appreciate you, Melanie. You're becoming the go-to for review of a majority of cases with great value. For your attorney. Oh, thank you for my attorney POV. Thanks again. Much love and respect, Brad. Thank you, Brad, for your 20. I'll take it. I'll allow it. Thank you so much. Happy 1 year anniversary to me and Laura Riker. Thank you. She says, I'm her favorite #1 channel. Thank you so much. Tom Duckery says, Mary Fitz. Pretzel Judge Freniere. Exactly that, Melanie. Exactly that. Now, here's the thing. Interlocutory appeals in Massachusetts. Where are my Massachusetts attorneys in the chat? Massachusetts for those, an interlocutory appeal is one that you can take before or during the trial. You don't have to wait for the conclusion of the case to do an interlocutory appeal. If I recall correctly, they have very slim grounds. Let's see what they are. Meaning, oh, Tom, if you're here, can they do an interlocutory appeal on this suppression issue? Where's the I think you can. Hold on. It says here. Tom says not likely in a criminal case. Well, listen to what I'm reading here in the note, the reporter's notes. Amended Rule 15A2 implements the late filing procedures mandated by this SJC in Commonwealth v. Jordan for interlocutory appeals of an order determining a motion to suppress. Former Rule 15A2 did not specify what showing an applicant for such relief must make concerning the timeliness of the necessary filings, hampering the efforts of a single justices to be consistent in addressing the threshold issue of whether the notice of appeal and application for leave to appeal were timely filed, and if not, whether they should nevertheless be considered. Can you go up to a single justice on a suppression issue? They don't like piecemeal appeals, says, but I mean, so he has to be convicted before he's allowed to appeal this issue. That can't be fair. We're right. Hold on, let me just see grounds. But nothing is as it seems. It should be in Massachusetts, right? Let's see grounds. All right, here we go. Criminal Procedure Rule 15. Interlocutory appeal. Right of appeal where a motion to suppress evidence is determined. A defendant or the Commonwealth shall have the right. I'm going to put this up on the screen so that you don't think I'm just making it up. Because we like receipts here. We like receipts here. That's why we don't do the gossip. All right, let's get rid of this. Unless I got to defend myself against the gossip that is being perpetuated against me. Hang on. Criminal Procedure Rule 15, interlocutory appeal. Where motion to suppress evidence is determined. This is number 2. Oh my gosh, it's so tiny. Hang on. A defendant or the Commonwealth shall have the right and opportunity to apply to a single justice of the SJC in the form and manner prescribed by a standing order of that court for leave to appeal an order determining a motion to suppress evidence prior to trial. If the single justice determines that the administration of justice would be facilitated, the court may grant that leave and may hear the appeal or may order it to the full SJC or the appeals court for determination. So it looks like it can be. Did I just teach Tom Kokanowski something? So it's slim grounds. It's motion to dismiss. Commonwealth shall have the right to appeal a decision granting a motion to dismiss a complaint or indictment. This is just interlocutory appeals. Defendant can apply to a single SJC. And that's it. You have to file a notice of appeal in the trial court within 30 days of the date of entry of the order. So they have 30 days from the 25th to file their notice of appeal. And that could perhaps stay the trial until it's decided if they decide to hear it. So there's that. So there we go. Oh, and it says, if an appeal or application therefore is taken by the Commonwealth, the appellate court, upon the written motion of the defendant supported by affidavit, shall determine and approve the payment to the defendant of his or her costs of appeal. So if the Commonwealth appeals, the defendant they may have to pay costs to the defendant and attorney's fees. And it says the trial, if the trial court issues an order which is subject to the interlocutory procedures herein, the trial of the case shall be stayed and the defendant shall not be placed in jeopardy until the interlocutory review has been waived or the period specified has expired. So there's that. This is, but the trial is supposed to start in what, October? Okay, so I'm Larry Tipton. I'm filing my notice of appeal. Toot sweet. Toot sweet. So I would imagine he will. He's a public defender. He's doing an amazing job. We saw him try the Penny McGee case. And so it is expensive to pursue, but he's being paid by the state. Brian Walshe doesn't have any money to pay him. He is guilty of sin. I agree. Mic drop? Maybe. But he shouldn't be tried based off of this info that's being illegally obtained. I agree. We have to stand up for the Constitution, right? And for constitutional rights of everyone, not just, people we like. Slippery slope, my friends. It's a slippery slope. Thanks, Alita. I just said that this must, of course, can this be appealed? Yes, there is the right of interlocutory appeal on the denial of a motion to suppress. And she took 31 pages to do it. She also rendered another 32-page decision, another 31. Wait, the other decision is also like 31 pages. We can do that one tomorrow. That's to suppress the search warrants on the cars and the houses, on the house. We can review that one tomorrow because it's getting hot in here. It's getting hot in here, but I can do that with you tomorrow if you want to come back and watch it. Because it's already been 3 hours, and many of you have been here for a long time, and a lot of people can't stand to watch streams that are 6 hours long. Terry became a new member. Welcome. Is it bias? Is it? I don't know. I don't know what it is. It's turning yourself into a pretzel to say that Bukhenik is more credible than attorney Tracy Miner. Somebody else said in the chat that the judge is friends with Tracy Miner, or that Tracy Miner is friends with Tracy Miner was friends with Ana, and so that's why the judge didn't believe her. But if Tracy Miner was friends with Ana, wouldn't she want to find Ana? Like, I don't know. I don't know anything. I'm beginning to think I'm being professionally gaslit by every single person in the Commonwealth of Massachusetts. Nikki said through Venmo, "Where's the OnlyFan when you need he, she, or them?" Right outside. Can you see me sweating? Oh, Tracy said, "I would never tell you how to run it, but I have to share because I know you support those of us with misophonia." Since she would be mentioned a lot in the Brian Walshe case, the noise when you say McLaughlin has the same effect on us as how you described how you feel about it. About fish. I'm sorry. I'm not a cupcake. I can't stop saying McLaughlin just because of misophonia. I'm sorry. I mean, I mute my mic when I slurp out of my drink. How about I'll give you a warning every time you're going to say it and you can mute it on your end? I mean, I'm not a cupcake. Can't please everybody, but thanks for your Venmo. It's comedy. It's humor, McLaughlin, the way I say McLaughlin, because we have to laugh sometimes or we're just going to cry. Maybe I can just go silent during that point. That was through Venmo, so thank you, Tracy. And Lisa, thank you for buying 3 matcha lattes from yesterday. And she said, "I hope you had a great vacation." Okay, thoughts, questions, comments, concerns before we wrap for the day. Thank you to everyone who told me the video was gone. The video is back, so go back and watch it. Although the entire first part about Dave Matthews is all cut out, as is any reference to Serena Vanderwoodsen and her husband, who is in Deadpool, and also anything regarding Brian Tully. So there's that. Thoughts, questions, comments, concern before we wrap. Make sure you have hit the notification bell. Make sure you have them all set. Also, make sure that you have your subscription up to date because YouTube has been doing crazy wonky things and they've been unsubscribing people against their will, non-consensually unsubscribing people. Gigi says that judge's decision was made before she took the bench. All they did was fill in the date. They sure love late on Fridays. Yeah. Yeah. Somebody said, I would love to have Tom on tomorrow. I don't know what Tom's doing tomorrow, but I'll ask him if he wants to come on. I have air conditioning. Thank you. Laura says, in Arizona, my rule to live by is never mess with someone whose air conditioner is broken. Hey, YouTube, Melanie's shows are cool, kind of class. Stop demonetizing the best law content available anywhere. It wasn't even that. They just disappeared the video. They said it's not a strike on your channel, but we're taking it down. You have to edit it. I appealed it. And then I don't even understand the rules, Laura. If I wish somebody could explain the rules. I wish I could call somebody on the phone at YouTube and they could tell me what the rules are. Tell me what is wrong with my video so that I can fix it. But they don't tell you. They just give you a vague, maybe sometimes timestamp, and that is it. Good luck to you. They're like, good luck to you. You can edit your video. Okay, well, tell me what's wrong with it. So number one, I don't do it again. And number two, I know where to edit it. Tracy says, our friend Mark says, the higher you go up the court chain, the less likely they follow the bad guy rule. The bad guy rule, meaning they don't believe the bad guys. I'm going to go jump in the pool. I mean, it's all right that I have no air conditioning. Don't feel bad for me or anything. It's just that my studio is really hot right now, but I'm here for you. I'm here for you. Okay. Oh, okay. Adam says, I've chatted the reason 4 times. The judge mentioned the minor's name. That's why I got to take it down. But no, it wasn't because the hearing part of my video is still up. Everything in the of the hearing is still up. Adam, it is whatever I discussed before the hearing that was objectionable. And they said harassment. And so that's it. It had nothing to do with the child's name or I thought it was the paramour's name because there was nothing in the hearing content that was objectionable to YouTube. So I don't know. I don't know what the hell it means because they don't really tell you. All right, my friends, if I don't see you soon, I'm going to die, but I'll see you tomorrow. So also, but explicitly stating that you're not going to accommodate a disability is not cool. Okay. Is this your first time here? Is this your first time here? It is really cringy when you say McLaughlin and not so funny. Kind of borders on bullying, even if she does suck. But I'm sorry, saying her name that way is bullying her? Is bullying her because somebody else in the courtroom once said it that way, and I repeat it. But explicitly stating you're not going to accommodate a disability is not cool. I'm sorry. I can't make everyone happy. I did not say that I'm not going to accommodate a disability. I didn't know misophonia was a protected class of people. And I said, I'll do my best. Okay? Have a nice time. Wherever it is that you find yourself going. Okay? If you don't like it, don't watch. I have muted my mic every time I take a sip of my drink to accommodate people who say that it bothers them when I swallow. A lot of people say, well, when I swallow my drink in the microphone. I also have people complaining that my intro is too long, that my intro sucks. I also have people complaining about a lot of other things about me, but I do not, I can't accommodate everyone and your feelings. I'm not going to change my intro for you. I'm not going to even continue addressing this because I just can't. So everyone, thank you for coming in for your free content today. It's free. Your content is free. You always have the ability to change the channel if you don't like it. And also, it's not an airport. You don't need to announce your departure. You don't need to announce your departure. I always use closed captions for my audience that can't hear or that can't hear properly. So I do everything I can to accommodate every single one of you. So everyone have a wonderful rest of your day, and haters gonna hate. And maybe you should go out there and hang around with that person. From Twitter, YouTube blocks all words that describe the horror we women and children go through, and it's frustrating. Thank you, Edwina. A lot of those words are blocked by me in the chat that I say, but I don't want people saying in the chat because they do look at the chat. People say they don't look at the chat, but they do. They have AI now. The AI is wonky, and there is that. And if don't complain that there's too many commercials during the stream, because again, you can get YouTube Premium and you will have no commercials, and it will cost you less than Netflix, and you'll be able to watch millions of your favorite people all the time. So there's that. Stay cool, stay kind, stay classy. I know that you can do it. I know that you can do it. Don't believe everything you read on the cesspool of Twitter. Yes, I do call it the cesspool of Twitter. Don't believe it, because I don't go on there under sock puppet accounts and attack other, I can't say creators, but another person who appears on other people's shows quite often lately. Stay cool, stay kind, stay classy, please. You can do it. I know you can. Peace. I'll see you tomorrow. Make sure you have your notifications set and smash the like button on your way out and on the way in. And thank the moderators, because without them, this wouldn't be as fun. Peace.